Okay. All right. Officer Henry, anything from probation?
No, sir.
Mr. Ellis?
Your Honor, I know that the court's overruled my 29C motion. I have asked my clients' parents if they've had any part in this. They have assured me they have not.
So let me address this. So I listened to a couple of jail calls. Mr. Deaton, it seems to me fairly apparent that you think, at least with regard to some of these charges, that you were wrongfully convicted, and that there might be some people out in the community that are trying to do something about that. That is not part of what I am doing here today. So I do sort of recognize the spot that you're in, because there's probably going to be an appeal to this. So this happens very frequently, where I have somebody who, they're not showing any remorse, but I'm sure Mr. Ellis is telling you, you still have an appeal. So it might not make sense to say a lot of the things that you might otherwise say. I sort of get all of that. I do agree with Ms. Tranter that there is an absence of remorse in this case, and an absence of accepting responsibility for the things that you were convicted of. But all of the, if the state wants to pursue charges for harassment of a victim or harassment of, that's all separate and apart from this. That is not part of the sentence that I am imposing in this case, other than what I talked about. So, Mr. Ellis, I apologize for interrupting. Go ahead.
Your Honor, all I was saying is I've known his father for years. He's in law enforcement. He knows better than to do that. He knows he could lose his job if he was any part of harassing someone in this respect. I don't vouch for people very often, but I've known him for years. He's always been honest. When he's testified, he's been honest, and he's always been honest with me about everything. I do not believe Parker's family has had any, and when I say, I'm going to say mother and father, I don't think they've had any part of any harassment at all. I'm not listened to the telephone calls, so I don't know how to really address those telephone calls since I haven't been privy to them.
Wait, did you not receive them?
No.
You did not receive them? Do you want to listen to them?
Yes.
Okay.
I can have them sent to him.
I apologize. I thought everybody was on that email. I got an email from the victim advocate that said we want.
Oh, I thought that came from pretrial.
I sent it to the pretrial services officer, Your Honor.
Okay, then it's on us that we did not properly distribute that. I guess we're going to have another misfire here because, do we just want to take they're not very long.
They're not very long. Yeah.
Just want to take some time to listen to them.
I want to hear them whatever the court wants to do. My morning is completely clear, so I can listen to them, and so that I'll be more informed on what's going on with these.
Okay. Mr. Ellis, if you want to listen to them, you can listen to them. I'm not going to impose consecutive sentences on Mr. Deaton. So
you are not going to?
I am not going to impose consecutive sentences on Mr. Deaton. The minimum sentence that is allowed by law is 25 to life. I think that imposing consecutive sentences would be the total sentence would be disproportionate to the conduct involved here and the danger posed by Mr. Deaton. But if you want to listen to those before we go forward with sentence, I will allow you to do that.
Your Honor, the reason I want to listen to them, because if there's things that I can address either with my client's family, I want to be able to address those issues, because as the court says, there's going to be an appeal. His conduct matters, and I want to hear what's going on the phone calls.
Before we proceed to sentence or after? Because he's going to get the minimum sentence.
I'll wait till after, but I do want to hear it before I leave today.
It is my fault that you were not provided them in advance. So we'll get them to you before you leave. Anything else?
No, Your Honor. my client would like to address the court.
All right, Mr. Deaton, what do you want to tell me about this?
Well,
You don't have to get up. You're fine sitting down.
first off, Your Honor, I just want to say that I'm very, extremely sorry to the victim and her family, my family, the courts, and all of Warren County as a whole community. And I can say the man's word and his honesty is everything that he stands for and everything he's worth. And if I knew Allison was anything below the age of 18, like I was told, I would not be here today. But I'm not here to deny that the law was broken. And that's why I cooperated and flew from New York to turn myself in whenever I was notified that I had warrants for my arrest. But I can say from the bottom of my heart that any female that I've ever came into contact with, I've never forced them to do anything and never will. Like Paris said, my father, he works as a police officer. My mom's a school teacher. I was raised to know right from wrong. And I know that the law was broken here. And I'm not here to deny that. But I know that I have never forced anyone to do anything. I'm a father myself, so I understand there's going to be punishment. And I'm willing to accept that. And my child, she has some disabilities. And her mother's not really in the best situation to raise her on her own. And all I want to do is be able to be an active father, to raise her, to have good morals, and standards to life, and raise her to be a good woman to society that I know she will be. And I can sit here and say, if I had any idea of the victim's age, we would not be in court today. If I could go back and change things, I would. People make mistakes, and I know that there's punishment that come with mistakes, and I'm willing to take that and accept that. I know I'm going to have to serve time in prison, and while I'm there, I'm going to do my best to educate other inmates, further my education, and be a positive impact on whoever I may be around, no matter the circumstances. I'm here today, and I don't think that I'm being wrongfully punished at all. I don't think I was wrongfully incriminated. But I do know that I had no intention or no motive at all to meet up with somebody under the age of 18. And if I knew the whole truth, we would not be here today. And I can put my hand on the Bible and say that, just like I told the detective who gave me the phone call in January to inform me that she was even, because up until then, I didn't even have any idea that she was anything less than 18 or that there was any problem. That's why I was so surprised. And whenever I was informed of this, it made me absolutely sick. And still to this day, and no matter what happens, what the outcome is, I know that the law was broken. And I can't change the past, but I know that going forward in the future, I'm going to do whatever I can to be the best man that I am and positively affect the world, no matter what the situation may be. And once again, I'm deeply sorry to everybody that this may have affected, whether it's the family of the victim herself, my family, my daughter, the county, all of America as a whole, because I know that's what the Constitution was in place for, is to make wrong right and right wrong. I basically know that I did something wrong, and that's why I turned myself in to correct what was wrong. And I can promise you it will never happen again. But I'm willing to register. I'm willing to accept whatever punishment may come. All I ask is that I'm granted a chance and an opportunity to show the county, the country, and the whole world that I can be a good person and positively affect people that I may be involved with, no matter who they are. And what I know is I made a terrible, terrible mistake that I'm deeply sorry to the court, the Constitution, the founding fathers, even everything that this country was built for. I know that I broke the law and I'm willing to take whatever punishment is given to me. And at the end of the day, all I can say is a man's word and his honesty is everything that he's worth. And I've told the truth to the detective. I'm telling the truth in court that if I knew Allison was anything under the age of 18, we wouldn't be here I wouldn't be punished and I wouldn't be charged. But I'm not denying the fact that the law was broken. And I know that there are mandatory punishments that come with this. And I will do whatever I have to do, whether it's programs, prison time, rehabilitation, education, government monitoring. Like I had the ankle monitor on for 4 or 5 months, I believe. I will abide whatever probation I'm given, whatever the punishment is, I'm willing to take that. And I know that I deserve that. And all I can say is I'm deeply sorry. And I know that what happened was very wrong. But all I ask is that I'm given an opportunity to show the court, show the world, the country, and every American citizen that's out there that Parker Deaton can be a good person, and he is a good person, and he has a big heart. My whole childhood, I was raised to know right from wrong. That's why I'm here today. That's why I turned myself in, and that's why I've been trying to cooperate and do everything that I can to show that Parker Deaton can be a good man, because he is. But that doesn't change the past of he's made mistakes or he's got caught up in the wrong things at the wrong time or whatever the situation may be. But I know and I can say that going forward, no matter what the outcome may be of this situation, I'm going to do what I can to positively affect the world and be a good man, because that's the person my father and my mother raised me to be. And everybody in my family, that's what our name means, is to be good people. And I feel that I have failed that. Like I was given in school a presidential award for my academics, and I made the honor roll every single semester because I like to think that I have a good head on my shoulders, but I know that the law was broken here, and I'm not here to deny that. And all I can say is, if I had any reason to believe that she was less than 18, like I was told, and not going to college, like I was told, then we wouldn't be here. You know, the only thing that I can ask for is an opportunity to prove to the world that Parker Deaton can be a good man, and he is a good man, and he will be a good man, no matter what happens, whether it's prison time or whatever happens. I'm willing to accept that, and I know the law was broken, but I can say that I had no foul intention, and I have never forced myself onto anybody, and I never will. That's all I have to say, Your Honor. Thank you.
So I do think you left something out, Mr. Deaton, and maybe you want to take the opportunity while you're here to say something else. But maybe what you want to say is, if there is anybody out there who is bothering this victim, harassing this victim, or making any kind of contact with this victim on your behalf, that they should stop that right now and never do that again.
Yes, sir. The court has the no contact order in place, and I expect everybody who knows me to be aware of that. And I know the rules to this, and if anybody has affected the victim in any way, that is completely my fault, because we wouldn't be here if I didn't make this grave mistake. All that I can say is whoever might be doing such a thing, it needs to stop, because that's not what a good American citizen would do. Because if you read the law and you read the scripture, it was broken, and there's no denying that.
So here's where we're at, Mr. Deaton. Most of your statement is inconsistent with the verdict in this case. And the way I read that is that you say the law is broken because the law is that you are not allowed to have any type of sexual conduct with a person under the age of 13, regardless of whether or not you knew how old they were. So the fact that you did not know the age of the victim is not a defense to that portion of the charge. There's also another part of the charge, though, that you were convicted of in counts 2 and counts 4, that you were convicted of compelling the victim to submit to this by force or threat of force. And I understand that you don't acknowledge that you did that, but that was the jury's finding. And so when you say, if she was over the 18, we wouldn't, if at the age of 18, we wouldn't be here, that's not true, because she testified that you did this against her will. And it doesn't matter if she's 13 or 11 or 18, 48, doesn't matter how old she is, we would still be here and we would still be in the same place, although with a different sentence. There is only one sentence in this case. That's 25 to life. I am going to impose that sentence on each of these counts. Even though they don't merge, I'm going to order that they be served concurrently, which means at the same time, because I think a 50 to life sentence would be disproportionate in the case. I am going to order that you register as a Tier 3 offender for the rest of your life with in-person verification every 90 days. And I find that you are indigent for the purposes of fines and costs, so there will be no financial sanction. And I'm going to give you credit for the 32 days that you have already done. Is there anything else we need to do or anything that I forgot? Because we have no Reagan tokes and we have no
Reagan tokes.
we have no post-release control with a
Life sentence.
indefinite sentence, right?
Okay.
That's my understanding.
Yeah, I believe that's correct, Judge. So I think you've covered it all then.
All right, you do have the right to appeal this to the 12th District Court of Appeals in Middletown. If you don't have the funds to hire a lawyer to obtain a transcript or to pay the costs, they will all be provided to you at no charge. You have 30 days from the date of the filing of the judgment entry of sentence to make an appeal as a matter of right. I anticipate that that's probably going to be filed later today, or the judgment entry of sentence is going to be filed later today. I do understand that you want to appeal this, right, Mr. Deaton?
Yes, sir.
All right. Mr. Ellis, would you be kind enough to file the notice of appeal? Mr. Ellis is not going to be your lawyer for the appeal, but I want to make sure that the notice of appeal gets filed. You can figure out if you have the funds to hire a lawyer or not. If you don't, then send us an affidavit of indigency and we will appoint a lawyer for you. If you're going to hire somebody, they'll know what to do and take over. But I want to make sure that the notice of appeal gets filed within a timely manner.
Your Honor, I will file the notice of appeal before this week's over.
Okay. All right. Good luck to you, Mr. Deaton.
Thank you, Your Honor.
Mr. Ellis, Ms. Idle did forward you the email from pretrial services that has the calls on it. Okay? All right. That's all.
You need this back?
I'm sitting out there, Lisa. People against Deborah Ann Lennox, 25-244-672. Come on up to the podium, ma'am. Your name?
Deborah Lyons.
You're charged with retail fraud.
Yeah.
You have the right to a lawyer. I'll be happy to give you one. You want an attorney to represent you?
You all need one?
Yes, I would get one. You don't know anything about the law, do you? Okay. All right, go have a seat out in the hallway and he will set you up with the court-appointed lawyer, okay? All right, Del Val, Jose Antonio Del Val Jr., 25R514276. Jose Del Val here. Your name, sir? You have to start your video. Mr. Del Val, you have to start your video. There you go. Your name?
Jose Del Valle.
You're charged with soliciting without a permit. You have the right to a lawyer. If you want one, I'll give you one. You want an attorney to represent you.
Sure.
I'm sorry, I didn't hear you.
Yes.
Okay, we're gonna set him up with an attorney online, this gentleman right here. All right, we'll put you in a breakout room. You just have to be patient. The lawyer has quite a few ahead of you. People against Tia Marie Trucking LLC, 25B149322, 25B149311A and B. Counsel, your appearance.
Good morning, Your Honor. Kenneth Thompson appearing on behalf of Tia Marie Trucking. Good to see you, Judge.
So on file 311A and B, as I understand, there's going to be a plea to overweight with agreed upon fines and costs of $2,100. And then on 25B149322, there's going to be a plea to overweight with agreed upon fines and costs of $1,500. True?
That's correct, Your Honor.
You
And I do.
authorize sending those pleas on behalf of the company?
Yes, I am authorized, Your Honor, to accept those pleas.
All right, on file 311A, to the charge of overweight, responsible or not responsible?
Responsible.
And then I'll accept that plea. Dismiss file B, which is defective equipment, fines cost $2,100. And then on 25B149322, to the charge of overweight, responsible or not responsible?
Responsible.
All right, I'll accept that plea, $1,500 fines and costs. So it's $2,100 and $1,500 respectively paid by October 18th, okay? Have a
Very
great
good.
day. Thank you.
Thank you very much, Your Honor. Thank you.
People against Saracen, Charles Christian Saracen, 25R514011, 25R514237, 25R514180. And I have another file, I'm sorry, 25R514011.
He's the sitter,
That's fine. 25R514237, 25R514001, and then I also have 25R514180. Your name, sir?
Charles.
You have an anti-blight charge and an inoperable motor vehicle. This citation was issued September 2nd. And then you owe money on 3 other cases, according to our records, $198, $165, and $198 respectively. So on 011, $198, 237, $165. And on 001, $198, you have the right to a lawyer. Would you like an attorney?
Yes.
Okay. You can go out in the hallway and we'll set you up with an attorney and then you'll speak with him or her, and either way you're coming back in here, okay? Thomas Stephen Chapman, 25B149246A and B. Morning, Mr. Baldwin. What case do you have here?
Poland.
Your name, sir?
Chapman.
You're charged with moving violation, causing serious impairment, causing a broken nose, and then you also have, that's on file A. And then you also have disobeyed traffic signal. You have the right to a lawyer on these. Would you like a lawyer?
Yeah.
It's up to you. I can't answer that for you. You didn't go to law school, right? Something like this, I would get one. We'll set you up with a lawyer. I'll go have a seat out in the hallway and he will set you up. People against Marcus Talafaro, Lovett, Fuller, 24B, 146-740A.
Thank you, Your Honor, and good morning. For the record, House Counsel Attorney Mike Baldwin on behalf of Mr. Fuller, sir, please state your full name. Mark Stoker. Thanks, Judge. We're back today on this sentencing on the
I'll put Beth in here. I need Beth. Okay.
I believe there were two considerations that the court wanted to emphasize completion. And one of them is he was to test. He did. He's compliant. Number two, he had the OWI, and Your Honor wanted him to clear that warrant. He has other outstanding warrants, and he's working through those. He's due to.
All right, let me just get the probation director over here, but I want to just summarize here. He was here on September 4th.
Correct.
There was a charge of failure to submit to twice monthly testing as ordered on August the 5th.
Correct.
And failure to clear all warrants. Those were the two charges, correct?
Yes, and then of particular interest to Your Honor was the OWI that you wanted addressed immediately, and it do that, and he also was tested, and he was reportedly he was.
All right. And he pled guilty to these two charges, or at least was found guilty. I don't remember if it was a plea or a finding. And then I told him to test that day. Ms. Reynolds, your name? Can't read my own writing. Where did I order him? On site, right?
Yes.
And then I set a sentencing for this morning at 8:45, and I said he was going to, it said, or at least my notes say, it appears he's going to 34th on September 15th. Did he do that?
Yes, I did.
What happened on that?
They set another court date for October 16th.
All right. Was his test negative?
His test was negative and he went as with the judge.
And what's your next court date, sir?
October 16th.
Moreover, Your Honor, you may remember he was paying an inflated rate of apartment rent. He lost that apartment, so now he has more money, and his objective is to funnel that in these warrants, predominantly at the 36th district. He's due to discharge in March of next year, so he has a plan to have all of these warrants cleared.
What was the offense date on the drunk driving out of the 34th? Can you tell me?
Yes, Your Honor, March 27th, 2023.
All right, but he was not on probation at that time here. What do you think?
He's compliant with everything else. He's very active and engaged in treatment. Mr. Fuller, from the beginning of probation really has turned it around as far as he does communicate with me. He went for this test. Counsel's correct. It was negative at on-site. I think the issue is he's dragging the feet, and that might be financially motivated as far as clearing up the warrants. He has 9 total outstanding warrants, and now this pending pre-trial in Romulus on October 16th. So that's where we're at, but all the other terms and conditions, he's compliant with. His SoberLink work program is completed. Everything else VIP, again, has been very spot on.
I just want to check out the warrants. It looks like most of them, at least.
I did print it this morning in preparation, Your Honor. I do have those highlighted if you want to see my printout.
No, that's okay. They're mostly for civil infractions, it appears, other than that one, correct?
That was the big concern, was 34th.
Right. All right. Any recommendation or anything you think?
At this point, Your Honor, I think a new date to clear those warrants. It sounds like, according to counsel, that Mr. Fuller sounds like he probably has a plan. He's in a financially better spot as far as hopefully being able to take care of this stuff.
You realize you got a violation, right? I mean, a lot of those happen on one show cause. But I remember you. I'm never going to forget you. I'm telling you, some of the nonsense he pulled in the beginning.
What it appears his pattern of behavior is he'll get himself in a situation, he lets it just kind of linger, and then he picks it up, and then he starts moving with it. And that seems to be a pattern. So I think he's on track and he's moving through the probationary process. He has a plan. As you may recall, he has a very good job. I believe that's with Ford. So he is gainfully employed. He is stabilized. He has residency. So I'm going to ask the court to allow him to continue on probation, allow him to continue doing the things that he needs to be taken care of so he can take care of his business.
Anything else you want to say, sir?
No, I'm okay.
I'm just going to tell you that I need another page of a register just to staple it on there. The problem I'm having. Yeah, I'm having a hard time forgetting what you did in the beginning. I mean, just total distrust I have right now. Being said, maybe you're getting better. Maybe that was a wake-up call. You're to pay additional costs of $75. You're to serve 1 day on the court work program and pay $35 for that. You're to serve 4 hours of community service by October 20. You are to clear all of your warrants by October 31, Mr. Fuller. I expect them all cleared by then. Do we understand one another?
Yes, sir.
Okay. So he owes 110 on this, and we'll set you up on the court work program. But go ahead. Was there something else?
You just need to clear, getting the matter resolved to fruition with the court is not what your honor's looking for. The system will move at its pace. He just wants you to clear the warrants.
He's going to have to pay those civil infractions.
Yeah.
Is the problem.
To clear the warrants.
All right. Can you pay the 110 now, or do you need 10?
I need time.
Pay by, I'll just say. How much time? Can I just say by October 1?
It's fine.
By October 1. Okay. Thank you. Thank you.
Hey, guys.
You need to see him?
Juan Alexander Ortiz. Do we have Mr. Carmen on this case, or this is 25B148377?
Michael A. Carmen, 37384, behalf of the defendant.
Let's go for it.
Do I have a Jacqueline Alayan here? Do I have any employee of Brownstown Forest View or anybody from Brownstown Forest View? Sir, your name?
Alexander Ortiz.
Mr. Kerman, your client pled guilty previously under section 771.1 to telephone harassment. He was referred for a screening and for a pre-sentence report. Have you had the opportunity to review the report with him, and are there any material additions, corrections, or deletions?
Your Honor, I have. There are not at this time, but just something I want to emphasize that currently Mr. Ortiz is a stay-at-home father, has 5 young children, all of whom are in school. He's doing some side construction jobs, but he's got his hands full with his children. Otherwise, factually accurate, and would ask the court to adopt the recommendations of probation.
I just want to make sure that Jacqueline Alayan is not here, Lisa. She's not here.
No, not on Zoom.
All right. Sir, is there anything that you would like to say?
I apologize to the court and my family.
Do you think any of these actions were appropriate here?
No, sir.
I don't, first of all, the calling her at her business repeatedly when they told you not to call is unacceptable. Let's take that and multiply that by 3. You're continuing to call there after the police told you not to when they were at the property On a scale of 1 to 10, that's a 10 that you still did that. You threatening to shoot up the place on a scale of 1 to 10 is 100,000. I don't understand these threats of violence out there anymore. In this day and age, when we got crazy people running all over the country that think that shooting people is fun, you don't threaten to shoot up a place. Maybe there's some demented human being in the world that would find that amusing. I'm not demented, and I don't find it the least bit amusing. Now, I'm telling you, you have any contact with that outfit over there, I'm telling you, you're going to jail for the rest of the probationary period that I can possibly give you. I'm sorry, for the balance of the jail term that I can possibly give you. Do you understand that? I don't even know how to handle this no contact. They have children. How are we going to handle that? He scares the devil out of me throwing.
We don't have children. Daryl's behind us. I'm not a threat at all.
You threaten to blow up a building and people.
I probably will never see that again.
Your Honor, he no longer has any reason whatsoever to be in contact with the facility or anything.
I just don't know what to do with these anymore. I mean, somebody has a bad day and they think they can threaten people. I just don't get it. Probation 771, you cannot leave the state without the consent of the court. You cannot violate any law or ordinance of any unit of government. If you change your address, your place of employment, or home telephone number, you must notify probation immediately. You have to report as directed. You're not to go near Brownstown Forest View, 19341 Allen Road in Brownstown. You're not to contact them. You're not to call them, write them, text them, email them, go anywhere near them. You're not to have any contact with Jacqueline Alayon. No contact with her at all. You're to attend a psychiatric evaluation and treatment if recommended. You're to attend an anger management program with 8-week follow-up. So again, you're not to go near Brownstown Forest View, 19341 Allen Road in Brownstown. No contact with Jacqueline Alayon. You're not to possess firearms of any kind. You're not to possess dangerous weapons of any kind. You're to obtain and maintain employment and provide proof, and you're also to obtain a high school diploma or GED. You're to clear all your warrants within 30 days. Five days court work program. There's a $35 a day charge for that for a total of $175. Fines $100, costs $125, 75 victim's rights fee, $50 justice assessment, $350, screening fee $60 for 410, probation fees are $240 for 650. We have court work program fees of $175. Your total is $8.25. If you violate, your probation could be revoked. You could be incarcerated for 90 days. You have 21 days to appeal, 14 days to apply for a court-appointed lawyer. This could have been a lot worse. Do not do that again. Give me a review hearing date, please, Lisa.
September 3rd of 26 at 9 o'clock.
September 3rd of 26 at 9 a.m. Now, can he pay all this today?
Okay.
How much do you have today?
Uh,
I'm sorry? When are you going to be able to pay this?
in a week.
I don't need you to pay it all in a week. You pay $100 per week. How's that? And I'll start it beginning on September 29th. Can you do that? If you don't have the money, you come to the court. I'll be glad to give you an extension, or you call the court on it before the due date, and I'll be happy to give you an extension. Whoa, scary. Good luck. You'll meet with probation before you leave. Todd Rutherford,
Thank you.
25R253193. Good morning, Mr. Shemke.
Good morning, Your Honor. Mr. Simpson, appearing to get my client in Brooks, be standing behind the
Your name, sir?
Todd Rutherford.
This is a disorderly charge.
Yes, Your Honor. There's an company case of Brownstone as well. But as to this case, wait for reading my client's statement.
I'll enter a not guilty plea. $500 personal bond. You cannot leave the state without the consent of the court or violate a law. You must appear in court as directed. No alcohol. There being an allegation that he was disorderly because he was intoxicated, at least in part. No alcohol, no illegal drugs, no marijuana, no contact with prosecution witnesses except through your lawyer. You cannot leave the state. You cannot violate a law. You must appear in court as directed. You understand all that?
Yes, sir.
Do you have any questions? And we're going to give you October 16th. That's when you meet, right? Or
Yes, Your Honor. I was going to ask for the second, but I spoke with the prosecutor for Rock, and he's not here on the second.
that's fine. October 16th, please say at
8:30.
8:30. Okay. All right. So you can go down the hall, sir. They're going to give you a paper notice and we'll see you back here. Do you have any questions?
Your Honor, I believe that there's one other company case, Mr. Rutherford upstate from there as well.
Todd Jeffrey Rutherford. This is file number 25B149205A and B.
Good morning, Your Honor. Mr. Shemke, appearing at my client, stands by me with
Phone.
Whose phone was that? I'm sorry.
So we got another disorderly public intox.
Yes, Your Honor. These the defense dates were back to back.
And then says he's got and we also got an animal cruelty case going.
Yes, Your Honor.
Do you have any idea what the allegations are?
No, Judge, we're getting the rings.
Keeping or harboring an animal in the kennel or otherwise willfully or negligently caused or permitted the animal to suffer unnecessary discomfort or pain.
If I were to speculate, Your Honor, I believe that my client was driving, we're waiting on a blood alcohol level to come back, and I assume that there was potentially an animal in the vehicle, but the animal was not injured.
But they've got another one here. Left his dog in a 2016 Dodge Ram. Vehicle was not running. The windows were up, the doors were locked, and the engine was off. Dog was beginning to show signs of distress due to the high heat index. Defendant refused to assist police in safely removing the dog. Police had to break the right rear window of the vehicle to remove the dog in order to ensure it would not continue to suffer unnecessary pain or discomfort. All right.
As the arraignment, we wait for the arraignment stands there.
He's got a super drunk.
Chief's okay.
Where's the dog at now?
Oh, she's at the house. My dog is very well taken care of, so my dog loves me.
I don't want you to talk about the case at all, sir. You shouldn't. But this was August 6th. Now, unless we were having an unseasonably, and I don't want to talk about it, cool day for August 6th, that would be completely inappropriate. So let's just back it up here. Where's the super drunk charge?
It's in Brownstone, Judge. I've spoken with Ms. Clayton fully. We anticipate that case coming to fruition before the next.
Is that in front of me or Judge Hesson?
Judge, it hasn't been
charged.
Hasn't gone forward yet, but with the blood alcohol level came back, I believe. I spoke with Ms. Caitlin Foley, indicated that there'll be a date that it happens before. We're going to walk in immediately after, so we'll be seeking to put the
I need another bond sheet, please. Are you married, sir?
No, sir.
Is there anybody else that lives at the residence with him, Mr. Shemke?
No, Your Honor, I know that he was married. He has fostered a kept good relations with their stepsons, and they're grown, and they don't reside with him.
This is getting a little bit more serious than I'm anticipating. What's your dog's name?
Sapphire.
These are all separate offense dates, were they not?
Yeah, nothing close to proximity, but 7 days.
All right, here's what I'm going to do. I need everybody to just give me 1 second here. All right, on the B file, 205B, because I'm setting separate bond conditions, these are the bond conditions on this. You cannot leave the state without the consent of the court. You cannot violate any law or ordinance. You must appear in court as directed. I'm going to give you your date again momentarily. You're to attend AANA twice a week. We're going to give you a form. You have to go in person. Every time you go, you have to have the form signed. Every time you come to court, you have to bring the form with you. You're not to have any contact with prosecution witnesses except through your lawyer. You're not to own, possess, or harbor any domestic animal other than that dog. So you're not to acquire any other dogs. You're not to own, possess, or harbor any other domestic animal other than that dog, Sapphire. You're not be on a SoberLink device by the end of the day. SoberLink device by the end of the day. I'm going to give you a court date, which is going to be on September the 18th as well on this one, Lisa. I'm sorry, on October the, what day did I give you?
October 16th.
I'm sorry?
The October 16th.
October 16th. And what time did I say on the other one, Lisa?
8:30.
Thank you. So that's when I'm setting all of these. October 16th at 8:30. And we will go from there, okay? Sir, do you understand all your bond conditions here?
Yes, sir.
Do you have any questions?
No, sir.
Okay, so you can go down the hall and get your notice. You're all set. Make sure you go to AA. Make sure he gets on the SoberLink by the end of the day.
Understood, Judge.
He can talk to probation, okay?
Understood.
Thank you. Martin Paul Stewart, 25F244536. Good morning, Mr. Robinson. Your name, please. How are you?
Good, Judge. Thank you. For the record, Steve Robinson appearing on behalf of Mr. Stewart.
All right. So what have I got here? I got an impeding. Your client needs to slow down.
Yeah, Mr. Kelly had indicated that to me, Judge. I will certainly pass that on.
Well, make sure he understands. I try not to get involved in what they're doing back there, but this one, I'm sorry. I don't even know if I feel comfortable taking this. What's he doing? I mean, does he want to be, if he wants to be a race car driver, tell him to get on the NASCAR circuit. I'm serious. He's got a horrible record. Yeah, I'm sorry. I'm going to let you appeal or tell everything. I'm just not going to do this. I'm sorry. It's nothing personal. You know that. He's got 10 traffic citations on here. If he wants to be a NASCAR, I'm not going to do anything to him.
Okay, Judge, can we just set it for a formal hearing, I guess?
Sure. I'll be glad to set it for a formal. Tell Mr. Cayley, John, I'm setting this for a formal, okay?
Which case is this?
In fact, ask him to come in. All right. Lisa, give me a formal hearing date on Flat Rock's docket, please.
October 2nd at 8:45.
Judge,
Yeah.
I thought I had my calendar next to me. Could the court give me about 10 seconds to grab it?
All right, take your time.
He's on the plan.
Good morning, Mr. Cayley. How are you? Your name?
What the fuck can I have to see if I-
I just can't take this to him. He's got too many tickets on here.
I told him he was pretty close to.
I mean, he's not only really close, he's way over. You know what I mean? I try not to say anything up here, but he's going to set it for a formal. So I just didn't want to blindside you. I'm going to tell you the date. It looks like if he's available, I'm going to do it October 7th at 8:45. This guy's got to learn to slow down. He's going to kill somebody or himself. Let me see what he just asked for about 10 seconds to see if he's available on that day.
Did you tell him the actual speed limit on that one?
I didn't mention it. It's 56 and a 40. But that isn't the point. Even if you go in 70 and a 40, but he's got like 12 of these on here. I mean, is it good that day, Mr. Robinson?
Did you say the second, Judge?
Yeah, at 8:45.
Excuse me. Yeah, that's fine.
And we should be ready to go, hopefully, right then, okay?
Sounds good.
All right, Mr. Robinson. Have a good day. Thank you.
No, Judge,
Thanks,
I
Mr.
understand.
Cayley.
Thanks, Roger.
Thank you. Philip Miller. Philip Joseph Miller, 25R514288. Good morning, sir. Your name?
Oh, Philip Miller.
You're going to plead to impeding traffic, right? All right. You're going to dismiss the 5 over to that charge of impeding traffic. Responsible or not responsible? All right. I'll accept your plea. Dismiss the original charge. 170 is your total. You can go right down to the cashier end of the hall. Okay. Have a good day. Bruce, Matthew Wade Bruce, 25R514162 A and B. Good morning. Your name?
Good morning.
So you're charged with driving on a suspended and resist, hinder, and obstruct, and you do have the right to a lawyer. If you want one, I'll give you.
Absolutely.
Would you like a lawyer?
Yes.
Okay. I'll be glad to give you a lawyer. You can go out in the hallway. You'll meet, he'll set you up with the lawyer. You just have to be patient. He's here. They both of them, I think, have a lot going on. So just be patient, okay? Thank you. And if either way you're coming back in front of me, Rodney Trustler. Rodney Richard Trustler Jr., 22M307-186. Your name?
Rodney Trustler.
How come you're not? All right, I'm just going to go ahead. You're feeling, this was a case where there was a lot of restitution on. I ordered $5,567.42 in restitution. I now have a charge that alleges you failed to pay fines and costs, which includes the restitution, in the amount of $6,147.42. That was as of September 8th. That is the charge. If you plead guilty, or if you're found guilty, you could be incarcerated on this case for up to 5 days. Do you understand that? Did you sign the advice of rights and read and understand the rights? You plead guilty, you'll be giving up all those rights, and there will be no hearing or trial. Do you understand that?
Yes.
You have the right to an attorney. I'll be happy to provide you with one, whether you can afford one or not at public expense. Do you understand that? Would you like a lawyer?
Yes, sir.
You waive your right to a lawyer?
Yes, sir.
To the charge you failed to pay your fines and costs and restitution, as ordered, with the balance owing as of September 8 of 25 in the amount of $6,147.42. How do you plead?
Right. That's why my payment sounds good. Because
That's what they think it is as of September 8.
so it should be 5 or less.
Pardon?
I just paid last night, so it should be 5 or less than that.
Okay. But as of that time, as of September 8th, how do you plead to that? Failed to pay? As ordered? Did you fail to pay as I ordered you to pay it?
I was late on one payment. So, Your Honor.
Hang on one second. Call in and we.
I paid this off that I received.
You paid the whole thing off?
No, so, the reason why I'm here is for a violation,
I know.
and I paid that.
Paid what?
There was like $500, so they wanted me to pay it within 30 days, and I paid that.
I told you all money was due on this by August 1 of 25. That's what I sentenced you to. This is September of 25.
Okay, but this was because of the violation. I just paid a $500.
Hang on a sec.
Sorry.
All I want to know is, do you have a balance of somewhere in the neighborhood of 614742 as of September 8th?
Yes.
So you're pleading guilty. Anybody force you to plead guilty? Plea is accepted. Why have you not been paying?
Paid about $6,000. So
$6,000.
yeah, it was like 12,000 or something.
It was 10,847 because this was handled by the Attorney General's office, as I recall, was it not? And there was a minimum 5,000 fines. I felt bad about having to impose that, but I did. And then you had restitution of 55, 67, 42. Here's your problem. I can only keep you on probation for 2 years.
I think I have house being sold. And I'm probably gonna be able to pay everything off with that. I'm gonna assume within the next 90 days, so I can still make my payments.
I just want you to be aware. All right, let me get Ms. Tassino over here. What are you doing for a living now? Are you a licensed contractor?
Painting and flooring and nothing that's.
Your name? What do you have to say on this? Anything? And right before you go on, Lisa, can you tell me the total balance right now? Is it in fact 56, 47, 42?
Yeah. Yes, it is. He just made a payment.
Go ahead.
Nothing else is done. It's just the money. I mean, I do think he's genuinely been making an effort. He's made several large payments. Just a lot of money.
I know. Put himself in a horrible position on this. All right, I'm gonna accept your plea. The failing to pay fines costs of 6147.42. I get the fact that that's before you made the $500 payment. I'm gonna set a sentence date in this. How long do you think until you're gonna have the balance?
I'm hoping with 90 days.
You gotta have it paid by April.
April.
Wait a minute, let me just double check one thing. I want to make sure you're still going to be on probation.
Is there, that's what I was gonna ask, that I have the maximum probation time?
18 months. No, your probation is expiring unless I extended it on October 9th.
Yeah, can't keep them past after April 9th, 26.
April.
I know, but all right.
I'm sorry.
All right, here's what I'm going to do. I'm going to go ahead. I'm going to keep you on probation. Probation's extended for 6 months until April 9 of 26. I'm not going to order any additional costs. I'm not going to order any additional probation fees. But you have to get some money in here. I'm going to set a payment plan. How much can you afford to pay per week?
I mean, I'm trying to get so money doesn't come in every week. So I make a $1,000 payment. I don't know what I've been paying. I just, when I get it, I pay it, but I can afford. So it's almost like $200 a week is what we were trying to get. So when we talked about it, I told you that. So this house that I'm doing is still the same one. So when this house sells, I'll get a large amount of money. So, and it's almost done. So I'm hoping I should be able to have it paid off.
All right.
If we can stay on the payment plan that we've been doing, if I can get
200 a week,
if I can get maybe 2,000 paid off in the next 2 months.
How about $200 a week starting October 6th and all money due by January 31 of 26? 200 per week beginning October 6th of 25, October 6th. That's about 2 weeks. And all money due by January 31 of 26. You think you can do that?
So let's, January. I'm hoping that as long as that house helps, and it will. So yeah.
If you don't have the money, that's what I'm ordering. If you don't have the money, you come talk to me on or before any of those due dates. I'll be reasonable with you. No, any one of these. If you're going to miss a payment of 200, you got to come talk to me.
So come here.
Right in here, on or before any of these due dates that you don't have the money in. So if you pay October 6th, 200, the same thing on the 13th, same thing on the 20th and the 27th, you can't pay, you have to come and talk to me.
Is there a chance I can?
Hang on. Or you can call the court and we'll go on Zoom on or before the due date and I'll do it by Zoom for you.
Is there a chance I could just lower it a little bit right now and then make the lump sum payment? It's just easier for me that way. That's
lower it to help. Hang on. I appreciate the fact, even though what I thought you did here was wrong, I'm going to still tell you that I think I appreciate the fact that you've at least tried. I will do that a little bit for you here. Let me do this. How about if I take the weekly payments to 100?
Yes.
100 per week beginning October 6th, all money due by January 31. Every week.
So it's still the same amount.
What did I say initially? I said 200 a week.
200 every other week.
No, I said 200 per week initially.
It's 2 every other week. That's where probation.
Yeah, there was 200, but you could
There was.
Well, it might have been initially.
Yeah.
I'm just saying now that there've been payments missed, we're running out of time kind of, right?
Oh,
I'll tell you what, I'll make it $125 bi-weekly. Beginning October 6th. All money due
thank you.
by January 31 of 26. So you have to start paying October 6th, all right?
Yes.
Good luck, sir. Thank you.
Thank you.
Marina Brabajewska, 25B1491661A and B. And could I have Anaya Greer seated at the table here, my right, your left? Come on up to the podium, name. Your name?
Marina Rajewska.
You're charged with assault and battery and public intoxication. You have the right to a lawyer. Would you like one?
Yes.
All right, you can go out in the hall. We'll set you up. Just, you have to be patient, okay? They're dealing with plenty of people, all right? And then either way, you're coming back in front of me. Thank you.
Thank you.
People against Anaya Kenyatta Greer. Thought I called her. Did I call Greer? Oh, she's on Zoom. I see. 25 F244382. Name, ma'am?
Anaya Greer.
All right. You're charged with public intoxication. You have the right to a lawyer. Would you like a lawyer?
No, thank you.
All right. So on July 26 of 25, it is alleged that you did commit the offense of disorderly conduct, public intox. They say you were highly intoxicated outside your aunt's apartment at 4:27 in the morning, and that you were kicking and banging and screaming at the door at 28526 Valley Creek Drive, apartment 505 in Flat Rock. That is a misdemeanor. It is punishable by up to $500 in fines, 90 days jail, costs for all of those penalties. Do you understand that?
Yes.
You're presumed innocent. They have to prove you guilty beyond a reasonable doubt. You have the right to remain silent, right to a trial by court or jury, right to question their witnesses, right to bring in your own. If you plead guilty at any time, you're going to be giving up all of those rights, and there will not be a hearing or a trial. Do you understand that?
Yes.
All right. Do you still wish to waive your right to a lawyer?
I don't feel I need one for this specific incident.
All right, I'm gonna enter a not guilty plea. I'm gonna give you a $500 personal bond. You don't have to post any money. I need a bond sheet. You cannot leave the state. Excuse me, without consent of the court. You cannot violate a law. You must appear in court as directed. No alcohol, no illegal drugs, no alcohol, no illegal drugs, no marijuana. You cannot have any contact with prosecution witnesses, and am I correct that you don't live far from your aunt?
No, we live right across the street from each other.
All right. All right, so I'm just going to indicate you have no contact with your aunt right now. Do you understand that?
Why is that?
I cannot understand the citation, but it seems to indicate that you were yelling and screaming at the door and pounding on the door of her apartment. So if she comes in next time and tells me she wants me to lift that, I will do so.
Yeah, because this incident involved my family, and the literal next day, we all made amends because they knew that, like, I was just overcoming postpartum. I went out and just got a little
Okay. You
excessive.
shouldn't really talk about the case. I'll tell you what, I will go ahead and lift that. I will lift that condition, but no contact with prosecution witnesses, no alcohol, marijuana, or illegal drugs. I'm going to send you into a breakout room shortly, but you just have to be patient. Why didn't you show up in person today?
Because when I received the notice, it said that I could either do it on Zoom or come in, and right now it was
Okay, I must have told my judicial clerk that too.
Yes, it was just easier for me today because I do have my child today with no babysitter.
I understand. How about in 2 weeks? Can you come in here? That would be what, Lisa, the 2nd?
It's October 2nd.
Yeah, can you come in here that day?
Yes, and
it's a lot easier when we have people here without lawyers in person. So you come in here October 2nd at 9 a.m. Is that all right?
Yes, I'm just a little confused on what's going on. I'm not.
You're being charged with a criminal offense of disorderly person, public intoxication. They think you were drunk. They think it was the early morning hours, sometime around 4 a.m. that you're banging and screaming at the door. I can't tell you anything other than that. That's all I know.
So right now, when you're telling me no alcohol and things like that, is it I'm being sentenced to probation and then you set the fine? What is that about as well?
You haven't been convicted of anything. That's a bond condition. I'm ordering you not to drink until we resolve this case or drug. Okay? Mm-hmm. October 2nd at 9, you're to be here in person. Okay?
Okay.
And all right. Best of luck. Any other questions?
Not at all.
Best of luck to you, ma'am. Deborah Ann Lennox, is your lawyer ready? Mr. Osmond, have you talked to the prosecutor yet?
Yep, I'm all set.
Oh, we got it. Okay, 1 second. What's your name, ma'am? Ashley what? Are you have a case here? Oh, were you just watching?
Yes, sir.
School?
Yep.
What school? Nice. You can go back and tell him what a mean guy I am now, huh? Stevens Disposal and Recycling, 25B149410A and B. How you doing, Mr. Osmond?
Very well, Your Honor. Thank you very much. Yes, Jeff Osmond on behalf of Stevens Disposal.
A misdemeanor, you stand mute, wait formal reading, right?
Yes, sir.
And then you're going to plead, you're authorized to enter a plea on behalf of the company to overweight violation with agreed upon fines and costs of $2,100, correct?
That is correct.
To that charge of overweight, responsible or not responsible?
Responsible.
All right, I'll accept the plea, fines cost $2,100. I'll dismiss the misdemeanor charge and the fines and costs to be paid by October the 18th to 25, okay?
Thank you very much, Your Honor. Have a good day.
You too, Mr. Osmond. Thank you. What grade are you in, young lady?
I'm a senior.
Okay, great. What are you going to next year? Harvard? Yale?
I want to go to Saginaw for criminal justice.
Fantastic. Well, it's good to have you here. Okay, I'm going to take this case. I'll be glad to talk to you. If you have any questions later, you can ask me and I'll be glad to.
Okay.
We'll make sure you get an A on that paper, okay? All right, good. Deborah Lennox. Deborah Ian Lennox, 25F244672.
Thanks again, Your Honor, House Counsel Attorney Mike Baldwin, for this Deborah Lennox Smith. Can you just please state the full legal name?
Deborah and Lennon.
Judge, for purposes of arraignment, my client stands being released from a reading.
All right.
Judge, we do have a proposed stipulated plea form that we tendered to the court. We're going to ask the court to consider a delayed sentence. 6 to 12 is what's being referenced in the report. She only has one, I think it'd be
Impaired charge before, right?
years to go.
Is that what you want to do, Ms. Lennox?
Yes.
If you plead guilty to retail fraud, I'll take it under section 771.1. I will set terms and conditions. I'll set a period of probation between 6 and 12 months. And if you're complying, I'll be more than happy to dismiss the case on motion to prosecutor. Do you understand that?
This is what we do.
You're the conviction will enter now. The conviction will enter now.
Okay.
I'll put you on probation. If you're compliant at the end of the probationary term, the prosecutor who offered you this is going to move to dismiss. Do you understand that? Is that what you want to do?
Yeah.
And did you sign an advice of rights and read it and understand it here today?
Yes.
If you plead guilty, you'll be giving up all those rights and there will be no hearing or trial. Do you understand that?
Yeah.
All right. Do you have any questions?
Yeah, these are things that we went over. She's just a little confused and upset.
Okay.
But she gets it.
All right. Meaning to the charge of retail fraud, how do you wish to plead?
Guilty.
Were you in the city of Flat Rock on Telegraph near Leonard and Flat Rock on August 23 of 25 at 7:34 p.m.?
Yes.
What business was that?
Dollar Tree.
And what did you do when you went into the Dollar Tree on that date?
May I, Your Honor? On that date, time, and place as stated by Your Honor, was this place open to the public?
Yes.
Did you retrieve some items of value?
Yes.
Okay, and did you exit all points of purchase without paying for those items?
Yes, sir.
Defense is satisfied, and this was your intent? It was your intent?
Yes.
What did you take, man?
Food.
Pardon?
Cat food.
Yeah, we're going to be asking that the court, as a condition, order a mental health evaluation.
Do you have a cat?
Several.
Pardon?
Several. I feel outside community. Okay. People helping strays. I don't think so.
So you went in to steal cat food that you feed to your cats and stray cats? Am I understanding you correctly?
Sure.
What was the value of that cat food?
Not very much.
There's a receipt in there, Judge. I saw it. I believe that item were recovered.
Yes, they were.
$13.63.
Yeah, we're asking for a mental health evaluation. My client and I are both in agreement. We need to figure out what's going on cognitively with her decision making. She's 65.
Yeah. I'm basically a good person, just said it was a little bit of bad that comes out. I don't think why. I'm not proud of it.
I think I want to do a report. I don't want to make this bigger than it is. I could sentence now, but she needs to get printed and photographed.
I think to the discretion of the court, Your Honor, we were looking for some type of resource to assist her in identifying the cognitive behavioral.
Ma'am, are you married? Ever been married?
Years ago.
Do you have, how's your financial situation?
Okay.
I mean,
It's social security.
All right. I'm gonna give you a personal bond of $500, okay? You don't have to post any money. You cannot leave the state without the consent of the court or violate a law. You must appear in court as directed. No contact with employees of the Flat Rock Dollar Tree. Or prosecution witnesses. You're not to enter that Dollar Tree store in Flat Rock or any other Dollar Tree. You cannot leave the state without consent. You cannot violate a law. You must appear in court as directed. You have to go over to Flat Rock to be fingerprinted and photographed. And I'm going to have them do a pre-sentence report. Have you ever had mental health treatment, ma'am?
No.
All right. Let's do October 2nd, Lisa. Is 8:30 good?
What date is that?
I can look at it.
Sure.
It should be fine.
Let's make sure.
October 2nd at 8:30 will be the date.
That's,
Ma'am, you have to go over and get fingerprinted and photographed at Flat Rock today.
The police department.
where's it going?
They'll explain it to you down the hall. They're going to give you the order. And I mean, I don't want you to lose sleep. You're certainly not going to jail. We just want to get you some help here, okay?
Yes, sir. That's what I want.
All right. Do you have any questions? So you go down the hall, pick up your notice, and then go over to probation right across the hall where they will interview you, okay? All right, good luck. Thomas Stephen Chapman, 25B149-246A and B.
Thank you, Judge. Again, House Counsel Attorney Mike Baldwin on Mr. Chapman. Sir, as you approach the podium, please state your full legal name for the record.
Your name, sir?
Stephen Chapman. Judge, for case A, the arraignment, my client stands mute with formal reading of the general information.
All right. I'll enter a not guilty plea.
Judge, we're going to adjourn this to allow the prosecutor to reach out to the complaining witness as to any potential out-of-pocket, direct out-of-pocket expenses. I'm going to ask that both A and B, realizing that B is a ticket, that these both be adjourned simultaneously together.
I don't believe he's ever been printed on this, so he has to go over to get printed at the Brownstown Police Department by 1 p.m. today, September the 18th. So I'll give you a personal bond of $2,000. You cannot leave the state without the consent of the court. You cannot violate any law or ordinance. You must appear in court as directed. No contact with the victim. No contact with prosecution witnesses. You have to go over to the Brownstown Police Department, be fingerprinted and photographed by 1 p.m. today, okay? We're going to give you an order for that. If you want a lawyer going forward, you're going to have to fill out a petition for one. I have to be, first court date, everybody's entitled to a lawyer, okay? And then the question is indigency. So I will go ahead and give you a date. Is it October 2, Lisa?
This is a Brownstown, October 16th.
I'm sorry.
October 16th at 8:45.
October 16th at 8:45 will be your next court date, sir. So you're going to go down the hall, you get your court date, you will get your order for prints, you'll go over to Brownstown, okay?
Judge, I'm going to hand him that form. There's a civil liability component to this case, and I think it would be paramount that, especially when the vehicle was owned by Chrysler, it was a work vehicle, and I asked him to fill out a petition for a court appointed attorney. I think it would be essential.
How much do you make at Chrysler?
Yeah.
Where do you work?
I work for a company, but I just hired local 1102 to get more arraignments.
To be a what? Okay. All right. So you fill that out, go down the hall and get your notice and take your order over to Brownstown. Good luck.
Thank you.
We'll see you on the 16th.
Yes, you can, Judge, he can sit at the table and fill out the paperwork, correct?
Sure.
Oh,
People against Charles Christian Saracen, 25R 514-180, 25R 514-001, 25R 514-237, 25R 514011.
My client's sitting.
Yeah, absolutely.
Morning, Your Honor, Mike Hillcroft, representative there.
Your name, sir? So he has one misdemeanor outstanding, anti-blight ordinance. Does he stand mute, waive formal reading on that?
Correct, Your Honor.
Not guilty, pleas entered. He's had these other cases outstanding. I'm going to give you a personal bond, Mr. Saracen. You cannot leave the state without the consent of the court. You cannot violate any law or ordinance. You must appear in court as direct. So I'll give you a personal bond. You don't have to post any money, but let me just cover one other thing with you. It says you're requesting an adjournment for compliance. So we're going to do
What, 30 days, Ron?
Give me somewhere close to 30 days, Lisa, please. This is
October 16th at 9 o'clock.
October 16th at 9 o'clock. Now, I want to caution you though, sir. You do have outstanding tickets here that are going to need to be paid. You have 198 plus 198, which is what? 396 plus 165. So you're somewhere in the neighborhood 496.5. 56, it looks like 561. So somewhere in that neighborhood, you're going to have to pay those. You understand that, sir? Now, these tickets, he's letting go. I mean, he's got June 23, July 21, June 9th. He's going to have to figure out a way to take care of this.
He's aware, Your Honor. He's going to be working on coming in with something for a payment arrangement.
If you want a court-appointed lawyer, you fill out a petition for one, sir. Do you have any questions? I can't hear a word you said. Okay, good luck. And then you'll go down the hall and get your notice. Thank you.
Fill out all the highway portion.
Do you have anything else ready or no? Or are we almost done?
Yeah.
Yes.
Caballero? Why is David Caballero? 25T646339. Name?
Caballero, Your Honor.
I have a charge that you failed to attend your scheduled probation visit on September 2 of 25. If you plead guilty or if you're found guilty, that would be your first technical violation. You could get 5 days. Do you understand that?
Plead guilty with reason, Your Honor. I understand, sorry.
All right, you understand that? And did you sign the advice of rights and read it and understand it? You plead guilty, you'll be giving up all those rights. There will be no hearing or trial. Do you understand that?
Yes.
You wish to have a lawyer represent you? I'll give you one if you want one. You sure? To the charge you failed to attend your scheduled visit on September 2nd of 25, how do you plead?
Guilty with.
Did you fail to attend? Why? How? For what reason?
In jail or in the hospital.
What's that?
I was either incarcerated, still in jail at the time of the,
You have proof that you were in custody during that time? Here's what I'm going to do. I'm going to go ahead and enter a not guilty plea. I'll give you some time to go get that information.
Still didn't report. I maybe could have told, you know.
Just listen to what I'm telling you. Just listen to what I'm telling you. I want proof that you were in jail or in the hospital on September 2nd. So I'm going to enter a not guilty plea, okay? I'm going to enter a not guilty plea. I'm going to give you a $250 bond. You cannot leave the state without the consent of the court or violate a law. You must appear in court as directed. Do you understand all that?
One thing I cannot afford the $250 bond.
There is no bond. I'm giving you a personal bond, okay? I'll just make a note. Defendant said he was in hospital on 9/2 or.
I believe I was incarcerated.
Or in custody.
Yeah.
To bring proof. Mr. Listen to me. Aren't you going to get tired of going to jail?
Speaking in all honesty to you, and you're an honorable man. I've seen had many days of hearing. I believe more honorable than some judges I've taken in front of. We're not talking about Ms. Holmes.
I don't need to talk about me or other judges. I just want you to know, aren't you tired of going to jail?
Yes, Your Honor, I just got out of metropolitan behavioral health. I think that you should know about it. I think other people should know about it. It's through Corwell and United Health Service. I have not felt this clear-minded since I left.
Good. Do you have a report from them?
Still current, I don't have a report from them.
Okay, get it.
I'm still currently under partial hospitalization. And they were supposed to pick me up this morning. This is a godsend. I didn't even know I had the show cause today. And they were supposed to pick me up this morning. They didn't. For some reason, they missed it. And then my mother was taking me and she got really enthralled while she was taking me. So I decided I didn't want to be in the car with her that long. So I decided to come to the courthouse, and that just so happened to be my show cause. I'm taking responsibility for what I've done. I'd like to get on the right track and move forward with my life.
Well, that sounds good. You were so young. How old are you again? If you behave yourself, you're gonna have 50 more years on the planet, at least 40 some.
Behavior.
Okay, well, that's fair. All right, Lisa, give me another date. I want you to go get proof of this, okay? What day are we gonna do this with him?
September 29th at 9:15.
Is that gonna give you enough time?
Yeah, I have to go there Monday through Friday.
Fine.
9:30 to 2:30.
September 29th at 9:15, bring proof that you were either in custody or in the hospital at the time of your probation visit, okay? All right, best of luck. Stay just one day at a time.
I just went to the A meeting at Way Serenity last night at 8:30. Got my 24 hours off it.
Great. Just work one day at a time.
Can I say something off the record?
Well, everything's on the record. All right, take care. Sure. We already done.
We're almost done. We're almost there.
Tiffany Janelle Epperson, 25W839557A and B. Epperson. We're going to issue a show cause on this. This is a first miss on the A file, so we'll issue a show cause, default judgment on the other file. People against. Washington. Jaquan Jalen Washington, 21W829-254. A and B. On the A file, defendant failed to appear. We're going to issue a bench warrant on this and forfeit bond. New bond. This is on, and I'm referring to the 254A file. Defendant's missed enough. New bond will be $6,000, 10%. This has been going on since 2021. And then on the other file, that's on the default judge, on the civil infraction charge. We're going to go ahead and indicate defendant failed to appear for show cause, applied bond. In other words, forfeit the bond, apply at the payment of fines and costs, and close this case, which is file 254B. So 254A will remain open, 254B will go from there. People against Chris Derrico Johnson, 25W839484A and B. On the A file, defendant failed to appear, will issue a show cause. On the B file, default judgment, people against Jason Andrew Bartel, 25W839334A and B. On the A file, $3,000, 10%. That was for failure to appear for show cause after so it's a second miss. And on file A, defendant was defaulted already on the 3rd of September. People against Lisa Marie Blair, 25W838228. Defendant failed to appear. We'll issue a warrant on this because this was failure to appear for a show cause, $3,000, 10%. Second miss, Keyshawn Deswan, Hooks to 5W839-402A and B on the B file. Warrant to issue bond to be forfeited for failure to appear for this show cause, 3,010%. And the A file, defendant was already defaulted on. People against Eugene Laskowski. Eugene.
I do.
State your name again for the record, please, sir.
J. Dingman.
All right, Mr. Dingman, your court's understanding is you're going to plead no contest to the charge of disturbing the peace. That is a misdemeanor punishable by up to 90 days in jail, $500 fine plus court costs. Do you understand that?
Yes, I do.
All right. Do you understand what a no contest plea is?
Yes, I do.
All right, two things about it I have to make sure that you understand. First of all, it means that you're not further desirous or wanting to contest this charge. You understand that?
Yes, I do.
Second thing is that for purposes of sentencing, the court's going to treat you the same as though you had pled guilty to the charge. You understand that, sir?
Yes, I understand.
Basis for the no contest plea?
A lack of recall.
All right. To that charge, how do you plead, sir?
I pleaded guilty.
Mr. Dingman, no contest is what we discussed. You'd have to state no contest if that's what you wish to do today.
No contest, please.
Thank you.
You understand that by pleading no contest, you will not have a trial of any kind.
Yes, I understand.
You signed or went through with your attorney an advice of rights form?
Yes.
Do you have any question regarding any of those rights?
No.
The rights under paragraph 5 are your trial rights. You understand that you're giving up those rights as well as all the rights that are on that form?
Yes, I do understand.
You understand you're giving up your right to appeal of right?
Yes, I understand.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today to get you to plead?
No.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily?
Yes.
And of your own free will?
Yes, I am.
All right. The court has been provided and has reviewed Pittsfield Township Department of Public Safety report for their case number 259660. Any objection to the court having reviewed that report?
No objection.
No.
Upon a review of that report, the court does find that there's a sufficient factual basis in which the court could determine the defendant's guilt of this offense. Mr. Dingman, I'd have to advise you that if between the time of my acceptance of your plea and the time of your sentencing, if you commit misconduct as defined by the Michigan court rules, you would not be entitled, the court would no longer be bound by any sentence evaluation or recommendation. You understand that, sir?
Yes, I understand.
You understand also you would not be entitled to withdraw your plea.
Okay, I understand.
Understand that? Okay. Counsel, are there any other promises, threats, or other inducements which have led to this plea?
No, Your Honor.
No, no.
And has the court complied with the court rule, and would it be proper to accept this defendant's plea?
Defense is satisfied.
People are satisfied.
Court will accept the defendant's plea of no contest to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 14A1 probation. Sentencing in this matter will be
October 8th at 9 a.m.
October 8th, 2025, 9 a.m. before me.
Your Honor, if I may address bond briefly on my client's behalf.
No, I was talking about that.
Thank you.
What happened this early, but go ahead.
Your Honor, I'm asking the court to consider a release on a personal bond. I did have a chance to meet with Mr. Dingman. This is the only matter holding him. He does have a cash bond on a 14B case that my understanding is to convert to a PR. If this case is converted to a PR, it's $1,000, 10% right now. Mr. Dingman has been complying with the probate order. He's been receiving his medication. This is a 90-day misdemeanor he pled to, and he currently has 55 days credit for time served. Based on that, I would ask for consideration for, or if not, maybe after he completes his PSI in custody.
Response.
Your Honor, we would leave it up to the court's discretion. He is currently undergoing treatment.
All right. What I will do is I'll grant your request and deny your request in part. His bond will become a PR after he's in probation.
Understood.
All right.
Thank you. Thank you, Judge.
Thank you. In part. Court does call the case of the People versus Dalton Hall.
We're ready then.
Good morning, Your Honor. Laura Lundberg on behalf of the people.
Lauren Brown, Deputy Chief Public Defender, appearing with and on behalf of Mr. Hall, who approaches from my right. Go ahead and state your name for the record.
My name is Dalton Hall. Thank you.
Your Honor, today is the date and time set for the probable cause conference. We just received some further information in this case. We would ask for a week adjournment so that we can process that and talk about options for my client. He needs to be informed of certain developments in this case.
All right, just procedurally, as to, he's not been arraigned on counts 5 and 6. I'll wait formal reading of those counts. And
yes, Your Honor.
He stands mute.
Yes, Your Honor.
Defendant having waived formal reading, standing mute as to those counts. Court will enter a not guilty plea.
Thank you.
Any objection to the 1 week adjournment?
No, Your Honor. I will also at this time move to dismiss counts 1 and 2 as they were corrected by adding those amended counts.
Gotcha. Okay. So I will dismiss counts 1 and 2 in this case. No objection, I'm presuming this.
No objection. Thank you.
You want a 1 week adjournment?
Yes, please.
So do you feel at your age, you don't have to give me a green sheet? No, that's okay. It's all right. I don't need an answer to that. I'll wait.
Let me okay. I got one for you. I'll get you one.
Probable cause conference in this case will be adjourned to the 25th.
All right. Thank you very much, Your Honor.
Continue. Court calls the case People versus Timothy Flood.
Ready, Your Honor. Good morning, Your Honor. Joe Simon on behalf of Mr. Flood, station agent Timothy Flood.
And at Mr. Simon's age.
Ouch.
Got me this year.
Mr. Vincent and Mr. Goldstein and I were having that discussion, Your Honor, and it is official that I cannot deny that age anymore. So I think I have to concede.
Very good.
In this case, Your Honor, I made a proposed resolution to Ms. Willenbring the other day that she's going to consider, we're asking the court to adjourn. Well, there's no commitments. I'm sure she's going to add that in a minute, but she's going to at least consider what I've offered.
All right. I can go to the 30th or the 9th.
The 9th, I'm traveling, Your Honor. And I don't know if just check the 30th real quick. I can do the 30th. Thank you.
Probable cause conference will be adjourned to September 30th, 2025, 9 a.m. Bond continued.
Thank you, Your Honor.
Thank you.
All right, Tim, you can get out of here. All right, see you.
Court does call the case of the People versus Winona Harvey.
We're ready. So that'll be next. Lauren Brown, Deputy Chief Public Defender, appearing with and on behalf of Ms. Harvey, who approaches.
Can you state your name, ma'am?
I don't know my name.
You don't know your name?
No.
Okay.
I can't use my first last name and I was born no middle name.
Okay. All right.
My family, nothing.
And what are we doing?
Your Honor, this matter is set for a competency review. We do not have an updated report in this matter. Does the court have an updated report?
I do not. I have not received a report.
And I believe it might be appropriate for us to wait to get an updated report.
You know my name?
Yes.
Winona Harvey.
Got it.
I'm appearing with and on behalf of Ms. Winona Harvey.
All right. Has anybody contacted the forensic center to see when a report might be forthcoming?
We've got no communication on that.
Ms. Lowe?
Yes, Ms. Akinruli had contacted prior, and initially they had said that the report would have been done by today, which is why we had it set.
Why we had it set for today, that's what I thought.
Still waiting.
All right, what I'll do is this, I'll adjourn the competency hearing to October 30th. We will move that date up if the report comes in pursuant to the statute. So October 30th, 2025, 9 a.m.
Thank you very much.
All right.
Okay.
Bond continue.
Thank you.
Let's call the case of People versus Jordan McKinney.
He was here earlier. When you look out in the hallway. David I. Goldstein, appearing on behalf of the defendant.
It'd take a while.
State your name, please.
Jordan McKinney.
Your Honor, I believe that the discovery has been provided. We're asking the matter be set for preliminary examination.
Yeah, for the record, I was prepared to make a very reasonable offer. It doesn't sound like we are in that stage. So we'll move on. Thank you.
Well, I will consider that between now and the date of the exam. I'm considering the
That would
offer.
make you very good. Thank you.
Okay.
Guys are done. Discovering having been completed, would the people have their witnesses? We're on the 30th.
Yes.
Sorry, what date, Your Honor? I'm sorry.
People have their witnesses available September 30th.
I believe so, Your Honor.
Preliminary examination in person will be set September 30th, 2025 at 9 a.m. before Judge Watt. The Wilkins. That's called the case of People versus Justin Scott.
That's called the people.
Right, Judge. Torshio Feaster, Assistant Public Defender, on behalf of Mr. Scott, who's approaching the podium. Mr. Scott, please state your name for the record.
Justin Scott.
Thank you, Judge. I spoke to my client. I reached out to the people on this matter. We are still negotiating. I'd ask for a 2-week adjournment, please.
I have 1 and 3.
Oh,
Well, I have the 30th.
Let's go the 3.
Pardon?
Let's do the 3, please, Judge.
The 9th.
Yes, Judge, because I'm going to ask you now for release to treatment.
Probable cause conference will be adjourned October 9th, 2025, 9 a.m. Bond will continue. If you send over the release treatment order, I will.
Thank you, Judge.
All right. Thank you. Thank you. Court calls the case of the People versus Christopher Coffey. Miss Wiley, approach, please.
Good morning, Your Honor. Jay Grant Miller, P58658, on behalf of Mr. Coffey, who I have not been able to locate.
Okay.
Oh.
I'm talking. Well, good morning. Good morning. Who was the prosecutor on this?
It's ring for people.
God, I hate to do this so early. Did you pull those?
I can for you.
Can I see counsel in back just momentarily? Court is standing brief recess, everybody.
Good night. Thank you very much.
What happened?
Ashley Feltus for the people.
Assistant Public Defender Chelsea Vergils with and on behalf of Anthony Williams, who is in custody.
I have this as an AG case.
I was looking at Jeffrey Williams, Your Honor. I apologize.
All right.
Anthony Williams.
All right. State your appearance, please.
Jesse Green, Special Assistant Attorney General, here on behalf of the people, Your Honor.
He's in custody.
Yes, Your Honor, we're planning on waiving the preliminary exam. I actually didn't sign the form.
No objection, Your Honor.
Anthony Williams. All right. He's waiving preliminary examination.
Yes, Your Honor.
Sir, is that a correct statement? Yes, sir. You understand that that's a proceeding where the people would have to show by probable cause that the offense alleged was committed and that you committed it? Yes, sir. You understand you'll not have that hearing. You'll proceed to circuit court for further resolution? Yes, sir. People also do waive their right.
Yes, Your Honor.
Preliminary examination having been waived, defendants bound over on a single count. Yes, sir.
We acknowledge receipt of the information, waive its formal reading, and stand mute.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea. Pretrial will be set for
September 30th at 1:30 with Judge Cummings.
September 30th, 2025, 1:30 before Judge Simpson. Bond will continue.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you, sir. Court does call the case of the people versus Rayshawn Dawson.
Morning, Your Honor.
Morning, Your Honor. Sam Bernstein with and on behalf of Mr. Dawson. Mr. Dawson, could you please state your name to the court?
Rayshawn Dawson. Thank you.
Your Honor, we're asking for an adjournment, please, to review discovery.
Without objection, probable cause conference will be adjourned October 9th, 2025, 9 a.m. Bond continue.
Thank you, Your Honor.
Thank you. Court calls the case People versus Douglas Brown.
Good morning, Your Honor. Michael Vincent on behalf of Douglas Brown. Mr. Brown, state your name.
Douglas Steele Brown, Your Honor. Excuse me. Good morning.
Good morning. Your Honor, this is a day probable cause conference, and I'm going to request an adjournment. We still have discovery to get.
Well, where's your?
Okay.
Yeah, exactly. I lost you there and I said, I'm not asking Vincent. Will October 9th work? All right.
Thank you, Your Honor.
Our cause conference will be adjourned October 9th, 2025, 9 a.m. Bond will continue. Thank you. Court calls the case People versus Terrence Ginyard.
Jesse Green, Special Assistant Attorney General, here on behalf of the people, Your Honor.
Thank you.
And Assistant Public Defender Jay Bellinger on behalf of Mr. Ginyard. Mr. Ginyard, can you please state your name for the record?
Terrence Ginyard. Go ahead.
And Your Honor, I am asking for an adjournment today. I have reached out to AAG Williams on this matter. I wasn't aware that a different AG might be covering today's case. So I am just seeking an offer from them. I did just get good contact information from my client as well. So I'm just seeking a 2 to 3 week adjournment.
Without objection, I'll adjourn this to October 9th, 2025, 9 a.m.
Your Honor, may I ask that we schedule for something after the 10th? We're concerned about a government shutdown, which would mean we wouldn't be able to appear for hearings.
Oh, that state government shutdown?
Yes, Your Honor.
Hold on a second.
Unfortunately.
But I'm a county.
I know you are, Your Honor, but.
No, I was just looking for time off. I'm just.
They wouldn't.
So you need something after the 10th, you believe?
Yes, Your Honor. Thank you.
So, well, he's out of custody. All tell you what, because I don't know what that means. I maybe have to read up on that. Let me go to October 23rd.
23rd. Thank you, Your Honor.
Yeah, all right. October 23rd, 2025, 9 a.m. Bond continued.
Thank you, Your Honor.
Thank you.
Who else? Your county?
Location, date, time. I need to be here next. Okay. And I will reach out with your new number as soon as I can.
All right.
Thank you. All right. Take care.
Yes, go ahead. Court calls the case People versus Quentin Coleman Ebersol.
Your Honor, good morning. Joe Simon on behalf of Mr. Ebersol. State your name, please.
Quentin Coleman Ebersol. All right, I have before me a plea form. That's what we're doing.
Yes, Your Honor.
Indicating that he's going to plead no contest to 3 charges. First charge is count 3, larceny 200 to 1,000. That's a misdemeanor punishable by up to 1 year incarceration. Also, intentionally dissemination, of sexually explicit visual material, 93-day misdemeanor, and count 5 of domestic violence, also a 93-day misdemeanor. Upon his successful plea to those 3 charges, counts 1 and 2 would be dismissed. There is an agreement that sentencing to be determined by probation, and that's the court's full understanding of the agreement. Is that correct?
That's correct.
Your Honor, that my client's ready to enter those pleas. Because he was in custody, I read to him all of the forms and he authorized me to sign on his behalf, and I reviewed them again with him this morning.
All right, very good. May I have him sworn?
Raise your right hand. Do you solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, and the truth so help you God?
Yes, I do.
State your name.
Speak up a little louder.
Quentin Coleman Ebersol.
All right. Sir, it is this court's understanding that you are going to be pleading no contest to 3 charges. Is that correct?
Yes, Your Honor.
All right. The first charge is count 3 of larceny 200 to 1,000. That is a misdemeanor punishable by up to 1 year incarceration, a $2,000 fine plus court costs. The fine could be increased at 3 times the value of the property taken. If that's greater than $2,000, that would become the maximum fine. You understand that, sir?
Yes, Your Honor.
Also, then count 4, which is the dissemination of sexually explicit visual material. That is a misdemeanor punishable by up to 93 days in jail, a $500 fine plus court costs. Do you understand that?
Yes, Your Honor.
And also then count 5, the charge of domestic violence, that's a misdemeanor punishable also by 93 days of jail, $500 fine plus court costs. Do you understand that?
Yes, Your Honor.
All right. Do you understand what a no contest plea is?
Yes, Your Honor.
All right. 2 things about it. I have to make sure that you understand. It first means that you're not further desirous or wanting to contest these 3 charges. You understand that?
Yes, Your Honor.
The second thing is that for purposes of sentencing, the court would treat you the same as though you had pled guilty. You understand that?
Yes, Your Honor.
You also understand, sir, that while I'm taking your plea, I would not be your sentencing judge. And you would be sentenced by Judge Fleischer in the 14A4 District Court.
Yes, Your Honor.
All right. Basis for the no contest plea.
Potential civil liability, Your Honor.
All right. Sir, to the charge of larceny, 200 to 1,000, how do you plead?
No contest.
To the charge of intentional dissemination of sexually explicit material, how do you plead?
No contest.
To the charge of domestic violence, how do you plead?
No contest.
Do you understand that by pleading no contest, you will not have a trial of any kind?
Yes, Your Honor.
All right. You went through an advice of rights form and had your counsel sign that on your behalf. Is that correct?
Yes, Your Honor.
Do you have any questions regarding any of the rights on that form?
No, Your Honor.
There's a copy on the podium. Please look at paragraph 5. You understand that because you're not having a trial, you're giving up those rights as well as all the rights that are contained on that form.
Yes, Your Honor.
You understand you're giving up your right to appeal outright.
Yes, Your Honor.
Are you on probation or parole?
No, Your Honor.
Has anybody promised you anything other than what's been stated here today to get you to plea?
No, Your Honor.
Anybody threaten you or coerce you?
No, Your Honor.
You're doing this voluntarily
Yes, Your Honor.
and of your own free will.
Yes, Your Honor.
The court has been provided and has reviewed Michigan Department of State Police report for their case number 5269-25. Any objections to the court having reviewed that report?
No objection from the people.
No, Your Honor.
Based upon a review of that report, the court does find that there's a sufficient factual basis in which the court could determine the guilt of the defendant with reference to these 3 charges. Sir, I do have to advise you that if you commit misconduct as defined by the Michigan court rules between the time of the acceptance of my plea and the time of sentencing, that you would not be entitled to withdraw your plea, and the court would not be bound by any sentence recommendation. You understand that, sir?
Yes, Your Honor.
All right. Counsel, are you aware of any other promises, threats, or inducements that have led to this plea?
People are not here.
No, Your Honor.
All right. And have I complied with the court rule, and would it be proper to accept this defendant's plea?
People are satisfied.
Yes, Your Honor.
Court will accept the defendant's pleas of no contest 2, counts 3, 4, and 5. Counts 1 and 2 are dismissed. Pre-sentence investigation and report is ordered at 14A4 probation. Sentencing in this matter will be
September 25th at 10:30 a.m.
September 25th, 2025, 10 a.m. before Judge Fleischer.
Your Honor, may I address bond? And with that hurried date, I'm telling my client, I didn't mean to take a minute to talk one thing. About just over 3 weeks ago, Your Honor, my client turned himself in on the court, revoked his bond. He had a $25,000 10% bond originally. He admitted violating his bond by placing his call to his former spouse, or estranged spouse. And she contacted the authorities, and obviously that's how he's in. I'm asking the court to consider reinstating that bond. The amount of time he served is pretty substantial, but he knows he earned it. He wants to get back to work. And he was on a GPS tether before, and he certainly would wait to be tethered again if released.
Response.
I believe it's in the court's discretion. I will say people are very concerned about the behavior of this defendant, not only as the basis for the offense itself, but then violating it after the offense occurred and after he was specifically told what the conditions were. This is a situation where we have no, I think it's best left up to the PSIR. We would be more comfortable with staying in custody until the court has been done. And then, of course, they can make that determination and recommendation to the court. But at this stage, there are too many concerns, and they're adding up to there to be an unsafe situation for this victim.
I'm going to deny your request to change his bond once certainly the pre-sentence investigation is done and you got a relatively quick sentencing date, certainly Judge Fleischer can make that decision. At this time, but motion for minor reduction is denied.
And I apologize, Your Honor, the court we have a change in address. Was that made already or should we approach it?
Change in address of.
For the no contact.
That should be communicated directly to community corrections. Well, actually, we're going to have the no contact. If that can be provided in writing, we'll make sure that the file is updated. Thank you. Court does call the case People versus Imbe. Is it indicate? Imbe.
Good morning, Your Honor. Assistant Plug Defender Davi Lebo for Mr. Ndiaye.
Yeah. Jesse Green, Special Assistant Attorney General on behalf of the people, Your Honor.
All right. He's waiving preliminary examination.
Yes, sir. He has executed waiver form, which I provided to the court.
Sir, is that correct? You're waiving preliminary examination?
Correct.
You understand that that's a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them.
Right.
You understand that?
Yes.
You understand you will not have that hearing and that you'll proceed to circuit court for further resolution.
Yes.
People also waive their rights.
Yes, Your Honor.
And Your Honor, I do just want to put on the record that we're waiving with an agreement of an offer available with a delayed sentence.
That's correct, Your Honor.
Preliminary examination having been waived, defendant is bound over to circuit court on both counts.
Thank you, Your Honor. We acknowledge receipt of the information and waive formal reading. Enter plea of mute at this time.
Defendant having waived formal reading standing mute, the court will enter a not guilty plea. Pretrial will be set for
November 6th at 1:30 with Judge Slay.
November 6, 2025, 1:30, Judge Slay.
Thank you, Your Honor.
Bond continued. Thank you.
Thank you, Your Honor. Have a great day.
You do the same, sir. Court does call the case of the People versus Dwayne Stevenson.
Good morning, Your Honor.
David I. Goldstein appearing on behalf of the defendant.
Your name, sir?
Dwayne Stevenson.
Thank you.
Your Honor, I believe I have all of the preliminary, discovery in this matter. We ask the matter be set for a preliminary examination.
People have their witnesses available the 30th. All right. Preliminary examination. We set September 30th, 2025. At 12 noon. That's before me.
I'm sorry, did you say 12 noon, Your Honor?
Yes, sir. Bond will continue. Thank you. Court does call the case of the People versus Abdel Motion Osman. People versus.
And good morning, Your Honor. Brandon Bird on behalf of Abdel Mosen Osman.
And ask about this, people in both cases.
Brown, case 25 F2 1031.
Your name, sir? Osman. All right. What are we doing?
Examination. Set preliminary examination and.
Is discovery complete?
Yes, Your Honor.
Mr. Bird, what do you wish to do?
Please, to set the preliminary examination, Your Honor.
Discovery is complete on your case?
As far as I know, Your Honor.
People have their witnesses available on the 30th?
Your Honor, we possibly go one more week.
Any objection from either side on that?
No, Your Honor.
No, Your Honor, that would be the 6th.
That I think it would be the 7th. Will that work?
It'll work, Your Honor. Thank you.
Preliminary examination in both these matters will be in person October 7th, 2025, 9 a.m. before Judge Fleischer.
Thank you.
Thank you.
Thank you. Bond will continue. Thank you. Court does call the case People versus Manuel Hunt. That one I see.
Yeah, no, I got it.
Mr. Byrd, you want to state your appearance?
Sorry, Your Honor. Yes, Your Honor. Good morning again. Brandon Byrd on behalf of Emmanuel Hunt. Mr. Hunt, can you please state your full name for the record?
Manuel Julius Hunt.
All right, what are we doing in this case?
Respectfully, Your Honor, I would like to ask for adjournment in this matter just to get all the discovery. Actually, I just got all the discovery yesterday, but we have a chance to go over it and go over with my client.
All right.
Your Honor, no objection to the adjournment. If there's any discovery that's outstanding, feel free to contact our office and I'll make sure you get everything.
All right.
There's also another matter, Your Honor. Unfortunately.
Yes, I have 1 in 3 weeks, counsel, which would you, well, I have the 30th. I can set it for that date. Will that work for you?
The 30th will work. The 30th will work, Your Honor.
All right.
Thank you.
Probable cause conference will then be adjourned. This is a Tuesday to September 30th, 2025, 9 a.m. Yes.
Your Honor,
Thank you, Your Honor.
Hang on. Go ahead.
Your Honor, I received information that this defendant has made, as of when we last checked, 19 calls to the victim. I'm sorry, since being arraigned, 19 calls at her listed phone number from his kin as well as other inmates' kin. And the communication is quite varied. There are a lot of calls. There are several concerning statements, though, regarding getting on her by why she's not getting out, talking about that this needs to go away and so on and so forth. And I'll make sure I share all of that with defense counsel. However, at this point, we would ask that his phone privileges be revoked. And if he wishes to have a hearing, we need a bond violation hearing.
Your Honor, we could definitely address the bond hearing on September 30th, but I haven't received any of these phone calls or any of this information to be able to have a valid argument against the prosecution at this point. So I respectfully ask to keep his bond the same until I have the evidence in front of me and I'm able to be on equal ground.
If you wish to have a hearing, certainly the court will grant you that. But at this time, based upon the representation, I'm going to revoke the defendant's phone privileges. His bond and all other aspects will continue. And then we'll see you on the 30th. Thank you.
Thank you, Your Honor.
The court does call the case of the People versus Gabriel Shawaka.
Good morning, Your Honor. Tina Sachs on behalf of Mr. Shawaka.
Your name, sir?
Gabriel Shawaka.
Thank you. What are we doing?
Your Honor, I'm asking for a preliminary exam date, please.
All discoveries complete.
To my knowledge, it is.
People have their witnesses available on the 30th. Preliminary examination in person will be set September 30th, 2025, 9 a.m. That is before Judge Fleischer. Bond will continue. Thank you.
Thank you.
Thank you, Your Honor.
Court does call the cases of the People versus Annie Oglesby.
But the next one, I'll be.
I'm waiting to see the picture from your, I think I know somebody that's on this. Yeah, so I'm gonna try and call them up and see what's going on with that. I'd say, Shamar, no, Shamar, maybe here. I'd say somebody.
Okay. I don't have an order on the 15th District Court case. I do have obviously one on the other case. But.
Okay. All right, then. Lauren Brown, Deputy Chief Public Defender.
appearing with and on behalf of Ms. Oglesby.
Hi.
Can you state your name?
And you're Annie Oglesby. All right, thank you. All right, I have all counsel here for the record. All right, what are we doing?
So, Your Honor, today is the date and time set for a probable cause conference. I do believe that our office has discovered a conflict in our representation, and we will be moving to withdrawal. So we may need to have an adjournment of this matter for that case.
All right. Saxon, on the one that you are on, what do you wish to do in that case?
Your Honor, we're asking that to be set for a preliminary exam.
All discovery is complete in that case.
The judges.
Yeah, I believe it is, Your Honor. Yes, I do believe it is, Your Honor. I have all video.
People have their witnesses available on the 30th.
Try, Your Honor, thank you.
Preliminary examination, that is in case 1022. Preliminary examination will be set in person for September 30th, 2025 at 12 noon. That's before me. Bond on that case will continue. On the other case,
Anna, what is my client's bond set at in the?
Pardon?
What is my client's or current client's bond set at in the 5753 case?
And it's a 1,000 cash or surety in that case. In the case before you, or that's your office is still on. In the other matter, I don't have an idea. Oh, in the case, because it looks like because of a bond violation, her bond is denied on.
Okay.
Your Honor, I'd like to make a bond motion in regards to that.
Hang on. In your case, Mr. Brown, I'll adjourn the probable cause. I'll just go 1 week out to 25th.
Thank you.
September 25th, 2025. 9 a.m. Well, actually, why don't I just go ahead? I'll just do it the 25th. And I'm presuming you're going to want to change in bond if there's a change in the other's bond. Go ahead, Ms. Saxon.
Your Honor, we understand the bond was revoked because Ms. Oglesby failed to test. She has arranged for to stay in Ypsilanti and be able to test. She'll be closer than she was living before. So I'm asking for a nominal bond to be set so she can go back to work, get reunited with her children, but also show that she is able to comply with the testing this time.
And for the record, Your Honor, my client has the same issues in this particular case. She would make a likewise request for a nominal bond.
But she is, well, she already in, well, but she didn't do anything in regard to the testing. She just didn't do not a thing.
When she got released, she went back to Jackson. She did not have transportation, or more importantly, she didn't have the money to pay. She has now made provision so that she can stay with her in-laws in Ypsilanti. Therefore, it would be easier.
I gave her 2 times to get this done, it looks like.
The first time, Your Honor,
I was incarcerated. Go ahead.
The first time, Your Honor, she was incarcerated in another county, and there was just a miscommunication. They did not know she was there, so she could not comply the first time.
Right. And so when she came down, I said, then you need to go to testing, and she didn't do it.
I think that was a transportation issue.
Yes.
She did say that she would call and was unsuccessful in able to get anything done that way.
Motion for bond reduction tonight. I'll reconsider it at the time of her exam, but at this point, I'm going to deny the motion. On both cases, bond will continue in both matters.
Thank you.
Thank you, Your Honor.
Court does call the case of People versus Taylor Adams.
Ashley Feltus for the people.
Assistant Public Defender Jay Bell on behalf of Mr. Adams, who approaches. Mr. Adams, can you please state your name for the record?
Taylor Adams. He's waiving.
He is waiving, Your Honor.
Sir, you're waiving your right to a preliminary examination?
Yes, sir.
You understand that that's a proceeding where the people would have to show by probable cause that the offense alleged was committed and that you committed it?
Yes, sir.
You understand you'll not have that hearing, you'll proceed to circuit court for further resolution?
Yes, sir.
People also waive their right.
Yes, Your Honor.
Preliminary examination having been waived, defendants bound over to circuit court on count one with two following. Mr. Bell.
Your Honor, we acknowledge receipt of information. Wait formal reading, stand mute at this time.
Defendant every way formal reading standing mute. Court will enter a not guilty plea as to both counts. Pretrial will be set for
November 18th at 1:30 with Judge Fleischer.
November 18, 2025, 1:30, Judge Conkey.
Thank you, Your Honor.
Bond continued.
Thank you, Your Honor.
Go.
She needs to sign.
We'll be in touch.
Court does call the case of People versus Taiwan felon.
Ashley Feltus for the people.
David I. Goldstein appearing on behalf of the defendant.
Taiwan Phelan.
Your Honor, we've had some preliminary discussions with regard to potential resolution in this matter. However, the person I need to speak to is Mr. Ganatra, and he's not available at this time. So we're going to be asking for a 1-week adjournment. If that's acceptable to the court.
Probably not, but what the heck. Probable cause conference will be adjourned September 25th, 2025. 9 a.m. Bond continues.
Your Honor, I would like to address the court on the issue of bond. I did alert Ms. Phelps. And if I call her Landy, I apologize. But anyway, Your Honor, my client is in this matter is charged with 3 counts. One is a maximum of 10. The other 2 are maximums of 5. They are nonviolent crimes. To my knowledge, my client has no prior criminal history and lives in Washtenaw County with his family. The other thing the court may or may not know is he does have a pending federal case which arises out of the same issues that are in this court, same weapons. And in that case, he's on an unsecured bond. So, Your Honor, I would ask the court, if the court is not going to consider a PR bond with a tether, that at least consider reducing the bond from $150,000 for a nonviolent crime with no prior criminal history. That seems excessive.
Response.
Your Honor, I do believe the bond is appropriately set. I'm trying to find the amount from my notes.
I have 150.
Cash or surety. That's what I have.
And Your Honor, this person was found to be in possession of several firearms. If I recall correctly, there was a 9mm Hellcat as well.
Mr. Swift. Yes, Your Honor. Ms. Hose pled guilty back on September the 2nd of this year to 1 count of forgery. I think there's a good chance she'll receive community control on this. However, she has a young child that is in the custody of Hamilton County Children's Services. There's a hearing coming up on September 23rd, 9:45 that she wants to be at. Also, since she's been locked up, she hasn't been able to visit with the child, and the child is how old?
3 months.
The child is 3 months old. She would request the court to grant her an OR bond. The court fails to do that. She would request wherever the court might send her that they allow her to visit with the child and attend the hearing on September 23rd.
Anything on behalf of the state?
The victim is opposed to any modification of the defendant's bond based on the length of time that this case has been pending. The state also does have concern. She has previously been absconded from this court for over a year. And so we do have concern about her ability and desire to present herself before this court. But we do understand what was discussed back in chambers.
All right. Ms. Hose, at this point in time, the reason that you are in custody is because you failed to appear for court. You have been absconded for a lengthy period of time. You had reached out to You had reached out to Officer Wilkerson from Court Services. She has secured a bed for you at We Care. They will transport you to your Children's Services hearing on the 23rd. The rest of this is on you. So I am, despite the objection of the state and the victim, I am going to grant you another chance on the bond. You will be placed on electronically monitored house arrest, which means if you leave We Care without the permission of this court or of the community corrections officer, your bond will once again be revoked. And then we won't be talking about probation. We'll be talking about incarceration. So this is on you. You have to take some responsibility. The situation with your children, with your child, with Children's Services, that predates anything that's going on here. This is an older case that should have already been resolved, but for your actions. So you need to take some responsibility for this. So I'm willing to grant you an OR. You'll be released to We Care on monitor, and they will transport you to that hearing. Other than going to that hearing, you are not to leave those premises. Are we clear on that?
Yes, sir.
If you leave the premises again without permission, I will revoke your bond, and then we'll be talking about incarceration as opposed to community control. You understand the difference?
Yes, sir.
All right.
Your Honor, if they allow her to, if they're willing to transfer her for visitation with the child, will that be permissible?
Yeah, as long as she stays on the monitor and she has permission from the community corrections first.
Thank you.
All right, that's all.
Yes.
Yeah.
Thanks, man.
So we still have to come back for,
Okay.
we still have to come back for your sentence.
Okay. So how do I, so how would that mean? Who has to come get?
We Care will come and get you. What do you mean?
Like, I will have to, I'll call them when I get back.
Yeah, they should transfer.
Yeah, because I'm, okay.
All right.
So,
Do we have a, if we have a sentencing date for her, don't we?
the 21st of October, I believe.
Your Honor, for the record, Jeff Fleischer, speaking on behalf of Ms. Marshall. Mr. Marion.
Mia Marshall. Good morning.
Your Honor, today is the time set for a pretrial in this matter. Prosecution wishes to dismiss these charges.
No.
Yes. I do that to accept that.
But he will. Is it all right with you if I dismiss this? All right. You have a lovely day.
Terrorizing this young lady off.
It was worth it, wasn't it? All right.
Thank you.
Before somebody changes their mind. Who's next? Mr. Myers, come on up.
Your Honor, for the record, Jeff Fleischer, 45367 Perigon Avenue. And with Mr. Myers. Your Honor, today, so could you tell the name?
Hello, Myers. Good morning.
Today is They access for pretrial in this matter, we are requesting a bench trial.
All right. Mr. Myers, do you understand that you do have a constitutional right to a jury trial? And you understand the difference between a jury trial and a bench trial? And you're waiving the jury, correct? All right, let's figure out what the date's going to be. Now I'm cold.
But person, you can't talk about the case at all, or not?
Well, you got an attorney, so you should get your advice from the attorney. So if the attorney thinks it's time to talk about the case, he'll tell you, but usually that's trial. I can't help you much with that because this case has got nothing to do with your impound. Right. No, the case. What we do with this case isn't stopping you from getting your car out of impound. That's between you and the impound lot. Because I didn't impound your car. You understand that? Usually they want money to give you your car back.
October 30th, 11:45.
11:45? All right, Mr. Myers, that work for you? All right. All right, we'll see you then. Heather's going to put a paper notice together and you can walk out with that in your hand.
All right, thank you.
You do know that the impound lot's probably charging you by the day.
They've been folded without, like, I mean, the first day, like, first week, and within there, I called and they're folded, little pieces open. I mean, they go to the air, it's hard to.
All right, something's wrong there because the PD would not be holding your car as evidence on a drove while license suspended charge.
But I don't think they'll use without license.
Yeah, but it's not because of the court case. Right. Who's got your car, sir? Towing. And they're telling you they're waiting on the court case? They've got nothing to do with this court case. Are you sure they're not? All right, Mr. Bodic, you might talk to Mr.
It would probably be the tech.
Greco.
Whole.
Yeah.
We put up a whole lot of vehicles.
On a fail to stop? In a DWS?
Out of that, I don't, when they did an inventory search, who knows what.
Oh, they might be waiting for some other charges to come.
There could be a whole lot.
Mr. Bodic, if you would ask Mr. Greco if he can look into that. So if, for example, because when they take your car into custody, they being PDs, they usually do an inventory search. If they found something in your car and they're thinking there might be further charges coming down the road, they might be waiting until they see what happens there. I'm just saying, I've got no hold on your car with these cases. Okay, I don't know what it is. I'm just telling you, I have no control over whether or not your car gets released. So he will talk to the prosecutor and see if the prosecutor can figure out why there's a hold on your car. If there's anything that we can do there, we'll try it. But I'm telling you, I haven't ordered an impound and I haven't told anybody not to release it. Understood?
Is there an attorney on that screen?
Yes. Which one you want to do next, Mr. Bowder?
We have the actor.
Oh, hold on. Mr. Myers. Are you on a payment plan with us? Are you in a position to commit to one now?
I'll start my job like literally next week. I was like 5 times.
Well, you don't have to start paying now. You just got to put it on paper. So if you want to start it, a month down the road, just get that set up today before you leave. All right?
Yeah, Mellon.
We need to file, right? Who's next, Mr. Bowditch?
We have District Maintenance.
Is that what I'm saying?
Patrick, is it Makus? How do you say it? Say it again. Come on up, Mr. Makus.
You're on for the record, Jeffrey Bowers, appearing on behalf of Mr. Mackins. You got today, date time set for pretrial. Not the prosecution, I remember the defendant.
Thank you.
Subject for approval. In this agreement, Mr. Mackins will be pleading responsibility for the civil infraction of impeding traffic. As it can agree to bond assess line $300.
All right. Mr. Mackins, it says here that you're going to plead responsible to an added civil infraction. You've agreed to pay fines and costs of $350, and the misdemeanor issued on June 11 or June 1 would be dismissed. Is that correct? And is that how you want to resolve this today?
Yes.
All right. Can you pay the $350 today? All right, go downstairs, get a smile from our cashier. She'll get you out of here when she's got your money, and we'll dismiss the original charge. Yeah, if you don't get a smile, come back up and let me know. 350 gets a smile. I'm gonna guess Bingle is next.
Yep. Figuring out the alpha with those labels. We can tell them.
Good morning, ma'am.
Your Honor, take time, sir. Right, but in this matter, we stand here. We have chance to pre-trial this case, we're going to execute a plea subject to court approval. In that agreement, Ms. Bingle would be pleading guilty to an added count, operating on visibly impaired, clearly understanding the original charge would be.
All right. Ma'am, did you discuss your rights and options with Mr. Bowditch? Understood those rights? Understand the options they give you? You understand the possible penalty for the charge? Added charge. Understanding all of that, are you pleading guilty freely and voluntarily today? You're doing this because it's best for you, not because he's trying to get out of here and go golf or something silly, right? I said something silly.
Before you look at.
August 17th, did you drive a vehicle in Belleville? Prior to driving, did you consume alcohol? Did you take a breath test or a blood test? Do you know the results?
Initial.
Stipulate.
0.16.
All right. Are you satisfied that I've received the facts I need to accept this plea?
Yes, sir.
So am I. I'll dismiss the original charge, ma'am. I'm going to do two things now. I'm going to send you down to my probation department to schedule a pre-sentence interview. Did you tell her how that works?
Yes, sir.
Okay. So you're going to schedule the interview. You'll find out when your sentencing date is, and I'm also going to put you on a personal bond. First two conditions are obvious conditions. No new charges and show up for the next court date. Third condition is do not purchase, possess, or consume any mood-altering substance unless you've got a doctor's script. Can you live with those rules? Yes. Raise your right hand. Do you swear or affirm and acknowledge the debt payable to the court in the amount of $1,000 if you screw that up? Any questions? You sure? Go downstairs and listen for your name. Probation will call you up to the counter.
Thank you.
Have a nice day.
Can I give you the benefits? Do you give the benefits? No, you have to be insured. Yes.
I'm going to pronounce it Awalumar. How do you say it?
You did. I think she's waiting for me.
Oh, you got Miss Medina's. I'm sorry. I'm sorry. Have a seat, ma'am. Wow, this is a good deal. If I'm reading it right. Speeding, stop sign. Just missing. Yeah. Fine. Did you warn Mr. Greco what was coming his way?
Not yet, but I will. Imagine that's kind of sliding in this thing, side.
You think?
Oh, you.
Are you cold?
Just
Seriously, I'm cold.
Will that bump it up for you?
No, she's all right. I'll suffer.
Hey, you, is Mariah with him? Hey, Tucker.
Yeah, hopefully you're not coming down.
No, I start my Thursday mornings in that restaurant, and it's always cold. So usually by the time I get here Thursday, I had a hoodie on this morning. Usually I'm cold, and usually by 10 o'clock I warm up, but I haven't.
Not on Thursday, no, we never do it. No, they both that.
Sport coat on. So maybe it's just because you haven't finished.
Uh-huh.
I'm almost to the point now where I'm not going anywhere without my puffy jacket.
Gotcha.
I went to the Hall of Justice.
Didn't have to make a $50 payment, so it was, Jonathan Jones's guy.
I don't think I told him he had to make a payment. I think I told him he had to make a payment plan.
He was told he just had to make a payment plan.
Judge, you might have to factor in that old age might be.
Oh, absolutely.
And then downstairs you complain about.
Absolutely.
Okay, so you know.
Absolutely. Although I've never run hot. So
I'm right behind you. I guess I'm waiting for the day.
you want me to bring some people in and try to find out who the hell they are?
Called downstairs and they can,
They're dealing with it.
somebody's gonna jump on.
We didn't approve that much Zoom, did we? Did we have all those people? Did we know those people were coming in Zoom?
Some of them are just, observers for a case. Wayne County, oh, he's bringing back. John. Oh, we very Hopkins file.
Top HOP.
And then we would adjourn it because he just needs a period of probation. We need to appreciate it. So it's like.
Wait, Tony, you have Martin,
Yes, ma'am.
Thank you. Miss Martin, did you get to speak to an attorney?
Yes, please.
I'll give you one. You could let Jeff or Andrew or Crystal know. I'll find them.
Okay, you need one or the other, right?
With it off.
Thanks.
It was not an off really, she picked it up. You just keep it out. Yes, it's paid more for each item short. Yeah, so.
This day is dragging.
Well, Brooke came in here, but he told her to go work in some more. Right. I'm joining him.
File and just hit him harder, $200 harder on that one file?
That's fine. That's fine. I'm fine with that.
All right. All right, Mr. Hildebrand, are you going forward today without benefit of an attorney?
On Zoom.
No, I am his attorney, Your Honor.
Oh, I didn't know that. Okay. Go ahead,
Yeah, I'm his
counsel.
attorney. Yeah, Stephen Mammon on behalf of the defendant, Your Honor. Today's the daytime set for pretrial in this arraignment pretrial in this matter, waive a formal reading of the charges and stay on mute and proceed to the pretrial, Your Honor. I had a chance to speak with opposing counsel Greco. He's agreed to dismiss the original charges. In exchange, my client will be pleading guilty to one count of failure to report with an added, the court indicated added $200 fine in exchange for the dismissal of all the civil infractions.
Thank you. Mr. Hildebrand, did you discuss your rights and options with counsel today? Did you discuss your rights and options with your attorney? Did you understand all those? You understand the possible penalty for fail to report, the added charge?
Yeah.
Understanding all of that, are you pleading guilty to that charge freely and voluntarily? Counsel, would you like to voir dire Mr. Hildebrandt to get me the facts to support the plea?
Sure. On the date and time
Showing
of
an
question,
incident date of April 21, counsel.
sure. On the date and time of question, were you in this jurisdiction of this court? Mr. Hildebrand?
Were you in
Were
the city of
juris-
Romulus on April 21? Go ahead, counsel.
And in that time, were you involved in a motor vehicle accident? And did you fail to report that accident to police?
Yeah.
Okay. Is the court satisfied?
I'm satisfied if you are.
I am, Your Honor.
All right, I'll dismiss both the original charges. What should I consider before I set the terms of sentence?
Your Honor, this was just a lapse of judgment. He got scared and made a bad decision. He's apologetic. Obviously, he's been engaged with this firm since the beginning, and he feels bad, and we'd ask that you just assess fines.
Yep. Are you working, sir?
All work right now.
All right. Where are you employed?
Well, they're calling another correct, but it shut down.
How long were you there? Holy cow. And when did they shut down?
June.
All right. All right. Anything you want me to consider before I sentence you? All right. All right. As I said, I've dismissed the original charges, fines and costs on the added charge, $400. Can you pay that today?
Yes.
All right. If you go downstairs, they'll call you up to the front counter. The cashier will smile when she takes your money and get you out of here. Thank you,
Thank you, Your Honor.
counsel.
No, have a good day.
You're all set, sir. We're going to computer it downstairs.
Jeremy, she's waiting for a meeting.
Heather, did Mr. Mamet log off? All right, we did resolve his 2 civil infractions. Did we talk about them, or I was distracted?
Just write them up and I'll grab them from you.
Got him. Okay, I'll come in. I got him.
For you.
Jane, do you know his defendant's name? Oh, it's civil infraction.
He's at a civil infraction.
Did you get your?
What's your last name, man?
Right here. I think we're waiting for Medina.
Oh, yeah, my notes, but I should remember. I think I can work off memory.
It's just a civil.
Yeah, it was just the act.
Are you coming in for Amani Iwaloma?
Yes,
Come on here. Paperwork tells me, oh, your appearance.
Christopher Medina, Your Honor, on behalf of Med. Your Honor, with regard to the arraignment, we would waive formal reading and stand. You know, I did have the opportunity to speak with my client. She is prepared to plead guilty to allowing an unlicensed driver to drive as well as respond.
That's not what I got. Oh, that is what that is. Oh, the scribbles confuse me. Go ahead.
So yes, and allowing in the speed 6 to 10, it will be dismissal of the TW, that's the open intox, and the original stop sign infraction.
Yep. All right. Ma'am, did you discuss your rights with her? Did you understand those rights and the options those rights give you? Did you understand, or do you understand the possible penalty for allowing an unlicensed driver to operate? Understanding all of these things, are you pleading guilty to that charge today? And are you doing so freely and voluntarily? Did you drive a vehicle in Romulus on August 9, 2025 while your license was suspended, revoked, or denied? Satisfied?
Satisfied, Your Honor. My client now has a valid license. She is a student.
Awesome.
University. She
Beautiful.
campus, she's a full student. She's also seeking employment. Your Honor, probably part-time employment, right, given her school.
Yep.
That is her current status, Judge. I would ask that the court impose fines and costs.
What are you studying? Good for you. Oh, you're getting there then. You're getting there. How's it going? Good for you. Good for you. All right. You still got family in Romulus?
Yeah.
Okay. All right. Anything you want me to consider before I sentence you? There's no magic answer. I'm just giving you a chance. Okay. All right. All right. And your license is reinstated. Okay. All right, so I've dismissed the original charges. On the 6 to 10 speeding ticket, fines and costs are $200. On the allow unlicensed driver to operate, the total on that file is $300 and 3 days on the court work program. We assess work program as an alternative to jail. You pick which 3 days you're scheduled. So hopefully you can work that around your school schedule. All right. So that's $500 total. Can you pay that today or you need to set something up? Do that downstairs. Any questions? Everything downstairs. Good luck in school.
Thank you so much, Your Honor.
You're welcome.
Oh, then, you know, you leave, you know.
Yeah.
Okay, thank you.
Have a good day, Murray.
Thank you, guys. Good mail, as well as I guess your agency just mail you one. Thanks, guys. Have a good day.
So I guess this thing Ashton was a little more formal than I thought, because I got a text from a buddy of mine said that his daughter's coming into their law class, criminal law class.
Well, you know, they were gonna, is he here on?
Yeah.
Because they were gonna come in during a probation day. Emily had set that up, that they were just about Sunday, but I mean, if they don't come in soon, they're gonna, we don't have it.
See much. And Ashton should know that, you would think.
Because you had the not Zoom travel free today. The whole judge.
Yeah, and that, I wanted to talk to Fred about that, because from 1 to 3, there's like sessions for the cops that I'm invited to listen in on. And then at 3, they start the actual mock trials, and at 5, then they, comments from me and the attorneys. But I'm thinking I might want to join on Zoom on one of the iPads, so I can just listen to what's going on while I do on base or whatever else I'm gonna do. And then I gotta get set up on Zoom at 3. Like Mariah's buying on.
Because I had asked for somebody to do those, yeah.
It's just sitting with what, something like that.
Yeah, something like that, and then like, oh, I've got to be there, and I'm like, here, follower, love, these guys.
He's trying to stare me down.
Hey, do you have a formal hearing date for a bell? I have to adjourn it to you guys. Okay, yep, thank you.
So I sent Stacy King a message asking for dates.
Days. Oh, okay.
The light is on, so yeah, my fear is they've set dates and they just didn't tell us about it.
Yes. Thank you very much.
Yeah, Cranny is now the librarian, obviously.
Oh.
She needed something that she could count on, whereas this liaison stuff is like a grant, so they don't know.
Kind of like the DV thing, that's a
Yeah,
grant.
exactly, yeah. And then Fudge called me. And he said he had taken a job where he can work from home because he's taking care of his mother. That's why they're hiring chief.
Yesterday, when so the village was not a lot of people, which was super, super nice. And we went over to the Eagle Tavern because I told Scott, so we walked on, like, I want to sit there and show you the drinks that they have. We get there and there's 3 of the like waiters, whatever, sitting outside, and I'm like, can we go in just to the bar? Sorry, I'm not a bartender today. I'm like, can't you figure out how to make it? I go, you're drinking something right now. And he's like, no, we can't do it. It has to be a bartender. Oh. So we didn't get anything, because I think that those were just the
And it
needed.
sounded like somebody just didn't show up for work. That's what it sounded like.
Yeah, but,
Wouldn't be dismissed,
96, 127, 496, I'm okay. Oh, you're.
yes.
Go ahead, Ms. Medina.
Crystal Marie Medina, Your Honor, on behalf of Ms. Henry, with regard to the arraignment, we would waive formal readings, and you, Ms. Henry, please say your full name for the record.
rename.
Thank you, ma'am.
Your Honor, Ms. Henry is prepared to plead responsible to dance you out of the license with a fine of $200 in exchange for destruction of property charge. Wouldn't be dismissed, then your standing the time would need an opportunity to pay. She would be able to settle the payment at the first floor, Your Honor. On the first floor.
All right, Miss Henry, is that the way you want to resolve these issues today? All right, fines and costs as agreed, $200. Go downstairs. They'll talk to you about your options.
Thank you very much.
You're welcome very much. So then I'm coming home. And it was like probably 3-ish. Northbound 23 either still was a parking lot or was a parking lot again. So yeah, there's just too damn many people on the road and too much construction.
Mm-hmm. It was just rush hour traffic everywhere. So that's like, I remember you used to like in the middle of the day, you would want to go somewhere because the roads were open.
Right.
Now it's just everybody's working from home.
So change of topic. Have you guys eaten at the Avenue in Wayne? It's actually, I think it's the Avenue Bistro or something like that, but it's between east and westbound Michigan, west of Wayne Road. Next time you guys want to treat yourselves, because it's not cheap. And did you say, all right, I'm having trouble hearing you for some reason, but you have a job, right? Go ahead.
Okay, can you hear me now?
Oh, much better. Thank you. So you have a job, you're employed somewhere, right?
Yes.
Yep. All right. Who are you employed by?
It's called SMS Solutions.
What do they do?
Basically, I'm like a cleaner right now.
Okay. All right. And what kind of shift do you work?
Graveyard shift. It's horrible.
So what
It's anywhere between second shift and third shift.
Okay. So what's that look like? When are you usually done working? What time you clock out?
Today I clocked out at 5:30 in the morning, 6 a.m. in the morning.
Okay. All right. So what's the problem with you doing the work program that was ordered?
So my job is in Detroit. I get a ride to my job. I stay probably like 40, anywhere between 30 to 40 minutes, depending on if I'm at my girlfriend's house or if I'm at my family's house. It's really just my ride and stuff like that.
All right. So you're living in Detroit and it's transportation issue to get out here to Romulus. Is that the problem?
Yeah. Yes, Your Honor.
Okay.
That's why I was trying to, that's why I presented to the court. I actually had my counselor call. I'm doing community service through my counselor center where I clean up around the building, restock stuff, help in the paperwork.
Where are you counseling at?
It's called the Detroit Recovery Project. It's on West Grand Boulevard.
Yep. I'm familiar. Okay. All right.
And I already have 210 hours to do. I think I completed 50 or so or whatever. I was just trying to see if you could apply my hours or days, however you see fit.
I'm not going to let you double dip. That's the problem.
Okay. Okay.
What's the status of your license?
It further got suspended when we went to court that day. It got suspended for another.
So when, if you know, when are you eligible for reinstatement of driving privileges?
Maybe like anywhere between 25 to 30 days, probably about a month out.
So by Christmas time, you should have a driver's license. Is that what you're telling me?
Yeah.
All right. So once you have a driver's license, is your transportation issue going to be at least partially resolved?
It should be. I should
All right,
have
so-
insurance and tags.
All right, so why don't we do this? Why don't we just have you reschedule your work days so they start after December 1? When you don't have to rely on somebody else to transport your butt out here 4 days.
Okay.
Is that doable?
Yeah, yes. Let's do
All
it.
right. And you think, and if you get your license straight before December 1 and you want to get the days done, then ask us to schedule them earlier than you had them. You follow me?
Yes.
All right. Any questions?
Nope.
All right. Are you noting that in your RLA? Okay. All right. Good luck.
All right, thank you.
You're welcome. Simmons, come on up. All right, Mr. Simmons, you are here today for 2 charges. Impeding traffic and drove without a valid license. The prosecutor tells me that based on the actions you've already taken, he will dismiss both the original charges if you plead responsible to double parking and agree to pay fines and costs of $180. Is that the way you want to resolve this today? All right. Simmons, Simmons. That's not on your docket. Thank you. All right. And I understand you either are in some kind of driving school. Oh, I'm sorry, Mr. Bowditch. I'm sorry. You're in some school or you've taken a class? You're done with this class? So what's the next step to a driver's license? All right. And refresh my memory. Where are you going to school? Senior this year? Junior? What's your cumulative GPA? Have you and I already had the grade point discussion? All right. 2.8. I'm going to guess it should probably be more like a 3.5 if you were applying yourself 100% to school academics. Okay. Mom, what do you think he's capable of grade point wise?
I will say
Better than a 2.8? Okay. All right. What do you want to do after high school, Mr. Simmons? I'm sorry, license to truck driver? All right. And the 180, can you pay it today?
Yeah.
I'll wait for his money. No, seriously, I'll put him on a payment plan. What's it? Because you didn't do this. He did this. All right. I mean, do you have some source of income that you can make payments if you commit to payments? You've been working. Working. Yeah. All right. So go downstairs and make a payment plan. So much a week, bi-weekly, monthly, whatever. I don't care. It's just regular payments. Both original charges are dismissed. Good luck in school this year. All right. Have a nice day. You're welcome so much. I'm sorry. Payment plan.
I put it, and that's the.
That's the way I did it. Yep. Yeah, the purple file, I just wrote dismissed the cost, but the paperwork's on top. Are you on Davis Harbor?
What is it? Was Morgan Measy or something?
You're on full record. Just vouch appearing on behalf of and with J.D. Harper Date. True. Tell Judge you need
Johnny Davis Harvey.
Good morning.
Your Honor, Your Honor, since date time set for ranging this fact with full agreement standing, Also had a chance to pre-try this case. We have an executed plea agreement subject to court. An agreement. It's Harper. Guilty to a charge of being a disorderly person with the understanding the matter taken under statute 771 for a period of 12 months. If we escape it's Harper, applies in all the court's issues. No trouble at that time, the court considered this dismissal. And she's going to be responsible for the beating. And agreed upon assessed fine on 80.
All right, I don't have anything in here about a delayed sentence. So what was the agreement about delayed sentence?
The disorderly person will be taken under 771 for a period of 12 months.
12 months. No, that's all right. All right, so I'll accept that with one change. I'm not going to take a plea to impeding traffic just to get $180 extra. I'll just charge her more on the misdemeanor, so there's only one file to process on the dispositions. Understood? Is that all right with you, ma'am? Same thing to you. We're getting in your pocket a little heavier, but it's just less work for my secretary. All right. All right, and did you discuss your rights and options with Mr. Bowditch today? Did you understand those rights and the options they give you? And do you understand the possible penalty for the charge of disorderly person?
Yeah.
Understanding all of that, are you pleading guilty freely and voluntarily to the charge? Mr. Bowditch, my incident date is August 8. If you can give me the facts I need.
Yes, sir. Okay. We driving in the city of Bronx. Yes. Where you pulled over by a policeman. And at that time, while we were involved with a police officer, did you find yourself getting a little bit high? Yes.
I'll accept the plea. I'll dismiss all the original charges. What should I consider before I sentence?
Your Honor, poor choice on that one given evening. This child is no problem to anyone and won't be in.
No prior criminal.
No.
Yeah. Working?
Yes.
Where at?
Legal left in the Delta Airport and also working as advertising.
Okay. So how many hours a week are you working? Both jobs combined? Roughly. Okay. All right. Anything else? Anything else you want me to consider? Okay. All right. All right. I think I already said it, dismiss all the original charges. I'll delay sentence for 12 months. During that time period, you stay out of trouble, no new criminal charges. I'm assessing $500 court costs and 3 days on the court work program. Can you pay the money today or do you need some options? You can set up or talk about your options downstairs. Work program is assessed, either one, as an alternative to jail. You pick which 3 days you work. You can do that downstairs as well. Any questions? Good luck.
Thank you, Your Honor.
You're welcome. We're going to wait for Ms. Medina on that one.
Expert, it's just an adjournment. Let's go on record prosecution.
All right. Derek Hamlin. Good morning, sir. Counsel, did you want to say something on the Hamlin matter?
Not mine, Your Honor.
Oh, it's Greco.
Up to the jury.
All right. Is he in a breakout?
Yeah, we bring him in. I mean, he didn't break up.
I don't know. Jamie thought the prosecutor wanted to talk about this adjournment. Understand, we do not have an attorney on record for you. Your attorney's got to file what we call an appearance, just to say, hey, I'm the attorney. All right. So I just want to know what the prosecutor has to say, and then we'll give you a date. Mr. Greco. I already forgot his name. Hamlin?
Hamlin.
Mr. Greco, did you have something you wanted to say on the Hamlin matter before we give an adjourned pretrial date?
No, the court officer, Jamie, just came and asked me. I said, no, it's just an adjournment. He has his own retained attorney.
That's fine. Thank you. All right. You're ready whenever?
Yeah.
Okay. She'll get you a date. When they're going to be?
October 20th. And 30.
That work? October 20?
You'll be guys. You just take a seat and I'll get.
Mr. Bowditch, what do you have?
You already have first.
Yep.
Tragedy in their family. This young lady just lost her younger brother tragically.
Oh, good God.
And they were wondering if she could do some community service instead of the work program.
Let's see if I got her file still.
Hey, Governor, is there a leader?
Yeah, we're waiting for the dean to get the file to get us when I was like,
Is there a leader here?
Here, yes.
Jeff. I gotta make sure I got the right file. I'll do 40 hours community service. You want to do it on the record or just have her? You just tell her.
I'll just tell us.
Let's do that by December 1.
What's happening is that where we can do it.
40 hours instead of 3 days. It's depending on one due date.
Thank you.
Sorry about your brother. I want those 40 hours completed by December 1. Doable? All right, we've got a list downstairs if you want to grab it. So you don't have to find someplace on your own. All right, good luck. Are we ready on Lear?
We are ready, Your Honor.
Appearances, please.
And Crystal Marie Medina, Your Honor, on behalf of Ms. Lear. Your Honor, Ms. Lear is not at this time. We do have the father here, Your Honor, which is her legal guardian. I have reviewed that paperwork, Your Honor. I'm confirming that we would be requesting an adjournment, Your Honor, to a Zoom date that may allow Ms. Lear to appear.
How far out do we want to go?
Say just like a month right now, sir. I mean, Your Honor, because we are going to kind of touch base then and see where we're at. Mr. Gill will be providing us some medical information with regards to his daughter that may be relevant to what we're trying to accomplish here, Your Honor.
That is accurate.
Thank you, Ms. Paulson.
October 20th at 10:40.
Sounds good to me. It's on Zoom, right?
Does that work?
Sorry, it's next. It'll be October 16th.
Okay.
Is that all right?
Do 10:50.
Perfect. Zoom, so I will, wherever I am, I'll be here. Okay?
I'm sorry, what time did you do that?
10:50.
Thank you. I'll make a note Zoom.
And sure, you have an email with my information, okay? All right. Thank you.
Good luck, Dad.
Thank you for your time.
I got a plea agreement. Hugo Palacios? No attorney? Okay. All right. Come on up. Are you going forward today without a court-appointed attorney? You want to talk to the attorney? To be honest with you, with this plea agreement, I don't think it's going to change a thing. Okay, so you made a deal with the prosecutor that you're going to plead responsible to double parking. You've agreed to pay $200 fines and costs, and both charges from June 8 would be dismissed. Is that the way you want to resolve this? Can you pay the $200 today? Go downstairs and see our cashier. We'll get you out of here as soon as we can. You're welcome. The original charges are dismissed. You're welcome. I'll do the double parking on the B. Oh, boy.
He's like, the shoes are $7.
All right, here, I can park. You think it's over here? My eyes are big, I'm sorry.
So when I'm reading. 50. Big word.
Of course, when you change some life, Scott can only do it, you know.
Man, this doc is just dragging.
So on Zoom, you have Nicole Martin, Deshaunda Stevenson, and Dirk Ross.
Are you talking to me here or Medina? I'm sorry.
If you want to grab their file, Ross and Stevenson are already checked in.
Steed, ST.
Yeah, Stevson. Stevenson. Should be Steve. What is it?
Stevenson.
Should be Stevenson. Okay.
Shauna.
Yeah. And then Green, Kelsey Green.
Yep.
Or in the main session. All right, thank you very much.
Judge, I mean, Boston.
Well, this.
How you want?
What do you got?
I have Mr. Feaster. Richard Feaster.
All right, Mr. Feaster, come on up.
Yeah. It's easy. Tell Judge me. Richard Feaster.
Good morning, sir.
The on today's date, time set for a retrial in this matter. Now the prosecution met Feaster got an executed plea agreement, which the state would be putting a disorderly person. Understanding that for the period of 6 months. Mr. Feaster stays out of trouble, complies with all the court's wishes. This matter will be considered for dismissal at that time. And I think right after that, he's going to the middle.
Where at? What branch? Oh, man, they're not gonna like the hair. I mean, I like the hair, don't get me wrong.
So about all of them cut hair.
Yeah. You know what? Just start getting haircuts so it's not such a big shock to your system to lose it all at once.
Look like mine, you can get on that ship.
All right, Mr. Feaster, did you talk to Mr. Bowditch about your rights and the options those rights give you? Understood those? And do you understand the possible penalty for this charge? Are you pleading guilty freely and voluntarily to the charge today? Mr. Bowditch, would you voir dire a June 24 incident date?
On June 24th. City of Rockville. Was there an incident that happened in the apartment complex? Were you present at that incident? And at that point, sir, Mr. Feaster, while that crowd was gathering, did you get a little loud? Yes. That's satisfying.
I'll accept the plea and dismiss the original charge. What should I know about Mr. Feaster other than his Navy plans?
In this apartment complex, wrong place and wrong.
You working, Mr. Feaster? Kind of, sort of. What does that mean? Okay, what's your uncle do? Okay. Have you ever had a job where you had a schedule and payroll withholdings and that kind of stuff? When? Where? Okay, so where was the last time you had what I call a real job? Okay. Anything else you want me to consider before I set the terms? All right, I'll go along with the prosecutor's recommendation. I will delay sentence for 6 months. During that time period, you stay out of trouble, no new criminal offenses. I'm assessing 3 days on the court work program as an alternative to jail and court costs of $350. Can you pay the $350 today? All right, go downstairs. Go downstairs, talk about your options. You can set up a plan, payment plan or a due date, and they'll schedule your 3 days on the work program. Any questions? Good luck.
Why's Madam involved?
Because-
She wasn't adjourned? No.
No, she was probably covering for Dave all the time.
Is anybody representing this account, Mr. Kaufman? I don't think so. He signed up for the prosecutor by himself. Yeah, just make the ROI show this the last time.
We got,
Yeah, Miss Lawson.
good morning, Ms. Lawson. Go ahead.
My name is Chloe Lawson.
Thank you.
Your Honor, today's date that's arraignment with the state. You also have a chance to pre-try this case. We have an executed plea agreement subject. In that agreement, Ms. Lawson to be pleading guilty to adding count of allowing an unlicensed private driver car.
Thank you.
Understanding the agreement charge would be dismissed. She is enjoying the mercy of this because she's paid off all her tickets and has her full license.
Reinstated. Good job. Awesome. Legal driver. Beautiful. All right. Did you discuss your rights and options with Mr. Bowditch today?
Yes.
Understood those rights and the options presented?
Yes.
You understand the possible penalty for the added charge? Yes. Understanding all of that, are you pleading guilty freely and voluntarily to that charge?
Yes.
July 5, 2025, did you drive a vehicle in Romulus while your license was suspended, revoked, or denied? I'm satisfied. All right. I will accept your plea. I'll dismiss the original charge. License is reinstated. Are you working, ma'am? Good. Good. How long you been with the city of Detroit? Okay, great. Anything else you want me to consider before I sentence you?
No, thank you.
You're welcome.
So you would find this, guys. Yeah.
How is this beautiful, but you worked different.
All right. Miss Lawson. Fines and costs on your file, $550. I'm assessing 3 days on the court work program as an alternative to jail. You pick which 3 days you work. Can you pay the $550 today, or do you need to talk options downstairs? They'll schedule your days on the work program as well. Any questions? Have a lovely day.
Thank you.
You're welcome. Who's talking to Martin on Zoom?
It was Medina. They had a plea worked out. I can bring Medina.
Okay, well, I'm done until somebody comes in. You waiting for an attorney, sir?
No.
You're waiting for her to give you a piece of paper?
Where is it?
Yep.
Perfect. Where am I now? Somewhere, the notes or something. I can't keep all of them memory, because I'm so recognizing, so disaster. After time. I can take her. And then I put it in the vessel, and then I'll do the other young man on Zoom. I'm trying to kind of and do. Somebody asked me about your work. Yes, Your Honor, I was just asked if I eat.
Human copy.
Not quite the same effect. All right, are you ready on Tiffany Hemingway?
Where is she? Give me 1 second.
I don't need her if you don't want her for dismissal.
The first one, do not be having. I am actually sending the attorney of record. This was a live trial. I believe there's dismissal in the file.
Done.
And I think expenditure was without prejudice.
How about Nicole Martin? Miss Martin, can you hear me?
Yes, sir.
Just state your name for Miss Medina.
Nicole Martin.
Thank you. Go ahead, Counsel.
He satisfied, Judge, my client is found to be guilty to driving while license suspended, revoked, or denied. I believe it's charge.
Yes.
In charge, Your Honor, in exchange in 2019, offense would be dismissed. I have advised her the 2 points of the driving record. My understanding, Your Honor, the only thing we have requested is she had police contact. She was given a $200 bond. She has not posted it with the intent that she wants to make sure the public court address this. And she's been frustrated for approximately 18 years. I asked that the court consider that. She maintains residence. She has a daughter that she's responsible for, and she hopes to return to her job in the nursing home.
Thank you. And Ms. Martin, do you understand your rights and options after discussing those with Ms. Medina?
Yes.
You understand the possible penalty for the charge of drove while license suspended, revoked, or denied?
Yes, sir.
Are you pleading guilty to that charge today?
Yes.
Are you doing so freely and voluntarily?
Yes.
April 19, 2018, did you drive a vehicle in the city of Romulus while your license was suspended, revoked, or denied?
Yes.
I will accept your plea to that charge. I will dismiss the other charge of drove while license suspended, revoked, or denied. I am going to sentence you to 18 days in jail, credit for time served, and close your file. Understood?
Yes.
All right. So you've also got a whole bunch of files you owe us money on. You're at a balance of over $2,000. What I want you to do is come in here in person and talk about what your options are. We've got a number of options so you can close these out so you can get your license straightened out eventually.
Yes, that's my plan, ASAP.
All right. All right. Any questions?
No.
All right. Good luck.
Thank you.
Yeah, nobody else at the jail. I can close the jail out. What do you got ready?
Dismissal.
Peters, got it right in front of me. Your appearance for Christian Peters.
Crystal Marie, Ms. Your Honor, on behalf of Ms. Peters, please state your full name for the record. Christian Peters. Your Honor, at this time, it's a final pre-trial. My understanding is that you are moved to dismiss and I have experienced my client with a dismissal without prejudice.
All right, with you if I dismiss it? Goodbye.
Thank you very much, Your Honor.
There's no solution.
Judge, what was that? This is.
What's that last one I dismissed? What was the charge?
The Davis one was no, are you guys talking about when he called that you heard? Peters or just?
That lady just.
She had an assault and battery.
Oh, yeah, that one, because it's a retrial, which quite often they do, set retrial seat, because that's actually show. If you run the long, push that, show, call the prosecutor, he doesn't see it going. It's that same trial, and that, but I'm not sure, right?
Thank you very much. I think you're welcome. I'm not going to be our case.
Quite often, it's, pretty.
Yeah, yeah, thank you so much for all. Bye.
Is the patterns of all the cops of the people.
Here, the dog barking. All right, goodbye.
You know, the rest of the product.
I already know I'm starting.
Yeah. I've had that, I was under that issue for probably 3 or 4 years. You should say bar without fire truck. It was no Stephen Barker.
Winston, Mr. Greco, your appearance for Romulus.
David Greco, on behalf of the city of Romulus.
All right. And Miss Winston, you're here for a formal hearing. Mr. Greco, it's been so long since we were doing formal hearings because we had a magistrate. I don't know that the formal hearing, and I hate to do this, but I don't know if the formal hearing should be in front of me. I had the informal hearing. That's not the norm.
Definitely not the norm, Your Honor, because
Yeah.
you've already heard the facts in the case and the formal hearing is supposed to be a review.
That's kind of what I'm looking at. Yeah. You understand that? Okay. So I already heard the informal hearing, right? So I already heard probably everything that would be heard today. I mean, there might be something new. I don't know. But generally speaking, if Judge A hears the informal hearing and it goes to a formal hearing, it goes to another judge. Otherwise, you're really not getting another review of the facts. You're getting the same person hearing the same facts. Understood? It's like appealing my decision to myself.
You didn't really get a chance to hear everything from.
Okay. Okay. Well, I can tell you this. I heard everything I wanted to hear because I always give people a chance to talk. But my point is, you're entitled to have this heard by one of my benchmates who hasn't been tainted with any prior hearing.
I'm confused right now.
I don't know what to do to fix that.
So we had this on court, then you moved it to so I can have stuff to support. To support.
Yeah, well, I set it for a formal hearing so that you can make a request for some discovery.
Right, which I did, but they still don't.
Right. Right. Okay, but that's not the issue right now. The issue right now is I think this formal hearing should be heard by one of the judges that aren't me.
Why is that?
I just explained that to you.
He's already made a decision on a case that's be responsible, so you probably don't want a
Okay.
review of that by somebody who's already.
I will want somebody else.
All right.
I'm in the middle of getting the date.
With who?
Judge Martin.
Pardon me, now there's this gonna be sent, notice now or sent mail?
We'll probably give her notice. Yeah.
Get your paper, okay, now?
All right. I suppose I could talk about the discovery issue if there was one. Any objection if I deal with that, just to hopefully save time for Judge Martin? Okay. So what have you requested from Mr. Greco as far as discovery?
Requested body cam information, but if we adjourn for a new judge, then by that time they should have the information that I need.
Okay.
I've never had a fight with any situation or
Okay.
any trouble, but this situation I was wrongfully accused.
That's,
So
you don't have to justify an exercise of your rights. You have a right to have a hearing. So do we know anything about a body cam?
Yeah, Robert. Ms. Winston and I spoke for the first time yesterday when I reached out to her. I'm not aware of being contacted by her whatsoever. I think she may be referring to the FOIA request because you're sitting around.
I called the Romulus police station so I could get it. And she told me exactly what I needed to do. She told me to email her for the information.
Did you do that?
Yes, I did.
Okay. So that she did request a discovery.
November
And
6th.
and Your Honor, I think FOIA is an appropriate thing. I'm getting into what discovery.
That's fine. What time?
I do have a question.
Hold on just a minute. So what we're looking at is a formal hearing by Zoom with Judge Martin, November 6th, 11 a.m. Does that work for everybody? November 6th, 11 a.m.
It's a Thursday.
You want.
Is that an option? I don't know. Go ahead and ask your questions while we're working on the date.
Get a lawyer or somebody representing, but I cannot.
You can get a lawyer, but you gotta hire one. Because the only time we appoint a lawyer on a matter is when there's jail time possible, and I can't put you in jail on a civil infraction. So if you want to hire a lawyer, you can. That's what a formal hearing is. Lawyers can be involved.
Yeah.
Need another day? It's got to be a morning date.
No, it's gonna be a problem.
You don't have to.
I'm sorry.
Can you do earlier than 11?
Did you got this file?
Nope. Haven't seen that file yet. What's the charge?
Well, that's my DUI, double pump, maybe it's a civil infraction.
No, there should be a misdemeanor file. It's not in this file, is it?
Oh, but
What is it? Lopez?
yeah, or the other way, except that.
That works for me, but.
Here it is. Just like I thought.
Mhm. Are you planning on hiring an attorney? Because you might not want to pick a date if there's going to be an.
Because the physical issue, we kind of like have lawyers, because I've gotten in trouble before and always had a lawyer, but they say because it's a traffic ticket, so it's like, but I don't understand how he has somebody, but I can't get anybody.
You can get, you have the ability to get one.
Yes, so I'm gonna continue to try.
Okay, all right.
November 20th at 11.
Does that work?
And does this depend on just his schedule? Not
No,
my,
that's why I'm asking you. Does it work?
the first day that you said was perfect for me.
Okay, but that's not an option because the officer is not available. So now I'm asking you, are you available on November 20?
We go with that choice.
What was that, the 6th? All right, November 6th, 11 a.m. Thank you, Corporal. All right. Anything else, ma'am? All right, we'll have a written notice for you in just a few minutes. Osario Lopez. Oh, Medina, we're waiting for your attorney.
Yeah, she's on Zoom trying to get that one.
Mr. Bowditch, would you like to stand in for a double parking? Mr. Lopez, okay, if this attorney stands in for Miss Medina?
Might be a translation problem, Judge.
Oh,
No. There is none? Oh. She told me.
Well, when I talked to Mr. Lopez originally,
Oh.
I asked him, if he would feel more comfortable with someone to violate. He said, get off the ground.
okay.
Father, taxpayer.
Go ahead.
Your Honor, for the record, Judge Bob, swearing on behalf of it, Lopez, could you tell me your name, record, please?
Miguel Osorio.
Thank you. I understand you're pleading responsible to double parking and added charge.
Yes.
You've agreed to pay fines and costs of $200. I'll accept your plea and dismiss the original misdemeanor. Can you pay the $200 today? Go downstairs, cashier will call your name, take your money with a smile and get you out of here. Oh, hold on, we got 2 files? Both files are dismissed. I did the double parking on the indecent exposure.
Oh, thanks for that.
Oh, that's it. Okay. The other one in the park?
We'll just go to.
No, there was a couple other ones. It was obscene something or other. Anything else?
Yes.
Who? Who?
Mr. Williams and Miss Hostley.
All right, come on up, Osler. Go ahead.
Awesome. And, Your Honor, today's date time set for the arraignment in this matter, wait for reading standing. You also have a chance to pre-trial this case, Your Honor, if you're an execute. Subject to court.
I understand you're pleading responsible to double parking, ma'am. And you've agreed to pay fines a cost of $250. Can you do that today? Same thing. Go get your smile from the cashier. We'll get you out of here. The misdemeanor is dismissed. Mr. Williams, you're welcome.
And Your Honor, for the record, Judge, I'm sure. That's your greatest, tell you, you have the record, please.
Thank you.
Your Honor, today's date that I've set for arraignment and it's not ready for reading, stand and eat. Also had a chance to pre-trial this case to an executing plea agreement in which Mr. Williams will be pleading guilty to an handicap allowing under started with the understanding the original charge of having an invalid license to be dismissed.
Thank you. Mr. Williams, did you discuss your rights and options with Mr. Bowditch today? You understand those rights and the options they give you? You understand the possible penalty for the charge? Understanding that, are you pleading guilty freely and voluntarily to that charge today? Did you drive a vehicle on April 23, 23 in Romulus?
No.
That's the date I've got. Okay, at that time, was your license invalid or improper? Satisfied, Mr. Bowditch?
Satisfied.
So am I. I'll dismiss the original charge.
School license back, Your Honor.
Awesome. We got a lot of those today. Yeah, good. It's a good day for drivers. Are you working? Okay. All right. All right. Anything else you want me to consider before I sentence you?
Hey, all my tickets, I was saying to read the public wants for already. So
Which you did. Yep. No warrants. Anything else you want me to consider?
reason I missed my last Zoom meeting because I had incident, I got shot.
Ouch. How you doing?
Feeling bad.
Good. Oh, lucky. Lucky. Good for you. All right. Anything else? All right. All right, Mr. Williams, fines and costs on your file, $600. I'm assessing 3 days on the court work program as an alternative to jail. Can you pay 6 today or do you need to talk options? Go downstairs and they'll talk about your options. They can also explain to you what your days.
But I mean, do you do, like, the government shield program, do that physical limitation where you can't do stuff?
I can't hear him.
Your Honor, because he had been shot, he got shot in the hand and it went through his hand and into his system.
Okay.
And I was informed that he might have limitations.
I'll give him a community service charity work option.
So instead of doing the work program, we could do community service.
40 hours.
Yeah. 12-1.
This is volunteer work, he said, it's a choice. I was just concerned about you.
So what's all we going to community service, then I ain't got to pay.
Nope. It's a time thing. You owe me money and time. So I can do up to 90 days in jail. I chose 3 days work program because of the injury you had. Mr. Bowditch has asked me to give you the option of community service charity work. I'll give you either option. I mean, if you want to do the work program, then you don't, it's not as much thinking involved. You just pick 3 days and show up. With the community service, you got to actually find a charity. We'll give you help. We'll give you a list, but you got to set something up with a charity and do 40 hours with the charity. It's up to you. Either option.
So you 3 days.
You want to do work program? All right. All right, you'll find out downstairs when you can schedule. Good luck.
No, I believe that they can figure out.
This is,
Yeah, Medina's busy on Zoom.
Yeah, we're doing Zoom and then, if you want to do this one real quick, that she just did.
the plea is to a no proof of insurance instead of false insurance.
I'm sorry, Your Honor, were you calling my case?
I was gonna have Mr. Bowditch take care of it if you were otherwise engaged.
Oh, Your Honor, for right now, I am available. Sorry, it is
That's fine.
Crystal Marie Medina on behalf of Mr. Bryson.
All right, go ahead. Mr. Bryson, can you hear us all right?
Yes.
State your name for the record, sir.
Darius Deshaun Bryson.
Thank you. Counsel?
Your Honor, my client is prepared to plead responsible to no proof of insurance.
That's the civil infraction?
Your Honor,
Correct.
$220 agreed upon fine.
Thank you. Mr. Bryson, can you pay the $220 today?
No, I cannot. I just recently got fired from my job yesterday. I can at least try to do a payment plan for where.
How much? How much? How often? When can you start?
I can start as soon as I get paid, which is next week.
How much?
And
How often?
I'm gonna put in $50 for the start.
Third time, how much? How often? I got the when, I got the how much, how often? Weekly, bi-weekly, monthly?
It would have to be bi-weekly.
All right, and next Friday is the 26th. Can you start then or you want to go into October?
I can start the 26th because that's when I'm gonna have my last paycheck, so I can start then.
Okay, all right, so $50 every 2 weeks, starting next Friday, the 26th of September. Original charge has been dismissed. Good luck.
Thank you.
Thank you, Your Honor, and then I could see the next person. Thank you. I'm sorry?
Are you able to go back into the meeting room?
What happened
Oh,
to that Miss
yes.
Green that was just up there?
I could go back in. Thank you.
There was a Miss Green that said waving. She
No,
disappeared.
I spoke with Ms. Green. We're ready to go.
Yeah, but she just disappeared. Oh, there she is. Miss Green, are you going forward today without the benefit of a court-appointed attorney?
Yes.
All right, Mr. Greco, what do we got?
We're going to amend the basic speed charge to a double parking $200 fine. We're going to dismiss the equipment violation and the fail to display. She has a valid license, Judge.
I'm sorry, fines and costs,
$200. Yep,
All right, and both, the other original charges would be dismissed, yes?
that's correct.
Ma'am, is that the way you want to resolve this today?
Yes, Your Honor.
Can you pay the $200 today?
No, I paid the $200 next Friday.
Say that again, it was garbled.
Sorry, I'm saying I can pay the $200 next Friday.
Next Friday, the 26th is a good due date?
Yes.
Done. The original charges are dismissed. Any questions?
No, sir.
Enjoy your day.
Thank you, you too.
Thank you.
Thank you, bye.
So I did that on the B file.
Everybody in Eggleston?
What is Eggleston?
Eggleston is a waiver date. Did he tell you guys about our felony exam days?
Yeah. Right.
Yeah. The other two don't live stream,
Okay,
but he does on his days.
okay.
They are still waiting to do them.
Okay.
I don't know if he told you those days or if you guys are just gonna come in.
Okay.
So seriously, if you guys like watching live court, there are a lot of judges that live stream, like we live stream just about everything. If I'm out here, we live stream. Okay. So if you just do a lot of court on YouTube.
You do those for your top one days. Okay. 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 Well, I guess we can put those up in Mr. Marketing.
Yeah, so I don't know about anybody else, but with us, if you go to our website, you'll see each one of the three judges listed, you just click on resume.
I just wait. Sorry. The variety.
Well, it takes, I think it takes you like 2 weeks.
Oh, okay. Okay.
Well, if you Google my name, my live stream, it's all around YouTube all the time. All these, you said you go like this. Like,
The other two don't live stream.
Okay.
what did I call it? Even, I didn't just start some bars.
Oh, yeah, me too. Yeah.
Yeah.
I use it. She's, how many people you got on right now?
Well, but it tells me how many, but he has, yeah.
See, so on it, I use the IMB files that you got. So you know, see, sure. Whatever, I got brushed by that, you were referencing that, I think it was like, I don't know, see. So, the other.
What's the word, man?
Oh.
There's again. They went, they've got off the bench, but they got back home.
That was actually, that was like TikTok, yeah.
Yeah, one word.
As a Glock, I can't recall what specific Glock it was, let's see, a 40 cal Glock 23. there was significant investigation into this person's social media. They were observed being on social media with these firearms. The search warrants were executed on his residence as well as his phone. And the search warrants indicate selling the firearms. They seem to be indicating that sort of activity, which is extremely concerning to the people. Seems to be a nature of, you want to still get this again. That's the only word I won't say on the record on the market. Yeah, I got this 23 and G2 right now. Yeah, slide through. I want that.
Your Honor, just briefly, I don't want to get into the facts of the case because this is not the prelim, but I would only indicate with regard to counts 1 and 2, that my client, having no prior felony conviction, with regard to the firearm that's in counts 1 and 2, it's not a crime for him to possess that firearm. The issue is whether he had any knowledge that the firearm was stolen, because counts 1 and 2 both talk about stolen property. I understand that count 3 might be more of an issue, but that's what the federal case is about. But again, Your Honor.
Well, is the feds going to take this case, or?
They're not going to, there's no indication that that's one of the things Mr. Ganatra and I need to talk about. We've had no indication that they're going to take it, but they have charged him for possession of the same gun that's charged in count 3. And they saw fit to give him a PR bond.
Well, that's the feds.
I'm just
not me.
I didn't say that, Judge. All I'm saying is that's a fact.
Well, they got a whole different way of doing stuff.
I don't disagree, Judge.
For bond reductions denied, certainly you can bring it up at the next hearing this time, but it's bond will at this point will continue.
I don't see it a couple times.
Court calls the case of the people versus, is it Hatiam Al-Shalabi?
Over to behalf of people.
Ready, Judge. Court shall cease to assistant public defender on behalf of my client. Please state your name for the record, sir.
Hatiam Al-Shalabi.
Thank you, Judge. I have had a chance to speak to my client and to the, with the prosecutor, still trying to find a resolution in this matter. We'd ask for a brief adjournment, Your Honor.
Hearing no objection, probable cause conference will be adjourned to October 9th, 2025.
Thank you very much, Judge.
Bond continue.
Thank you.
Thank you. Oh, okay. Let me do a couple. Why don't you? Take my one out. Oh, do it, sure. Court does call the case of the people versus Sherry Walker.
Yes, Your Honor. Brandon Bird on behalf of Sherry Walker. Ms. Walker, can you please state your full name for the record?
Sherry Walker. I have before me a plea form. Is that what we're doing today?
Yes, Your Honor.
Plea form indicates that the defendant will be pleading guilty to an added count 2 of retail fraud in the 2nd degree. That's a 1-year offense. Upon a successful plea to that charge, count 1 would be dismissed, although the sentencing judge waiver is checked on this. This is a SK 14A1 case, so it would remain with me. That's the court's full understanding of the agreement.
That's fine.
Yes, Your Honor, that's correct.
May I have her sworn?
Do you solemnly swear to affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
State your name.
Sherry Walker. So Walker, it's this court's understanding that you're going to plead guilty to the charge of retail fraud in the 2nd degree. That is a misdemeanor punishable by up to 1 year incarceration, a $2,000 fine plus court costs. Fine could be increased to 3 times the value of property taken. If that's greater than $2,000, that would become your maximum fine. You understand that?
Yes, sir.
All right. Still wish to plead guilty
Yes, sir.
to that charge? How do you plead?
Yes, sir.
How do you plead?
Guilty.
Now, you understand that by pleading guilty, you will not have a trial? Be kind.
Yes, sir.
All right. You had signed an advice, have you signed an advice of rights form?
Yes, sir.
All right. Any question regarding any of those rights?
No, sir.
All right. You'll see a copy on the podium. Paragraph 5, those are your rights which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes, sir.
You understand you're giving up your right to appeal of right.
Yes, sir.
Are you on probation or parole?
No, sir.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No, sir.
Somebody threatened you or coerced you?
No, sir.
You're doing this voluntarily
Yes, sir.
of your own free will
Yes, sir.
and because you believe that you are indeed guilty of this offense?
Yes, sir.
On June 12th, 2024, at the location of 3300 Carpenter Road, in Pittsfield Township, Washtenaw County, State of Michigan, what did you do at Home Depot that makes you think that you're guilty?
I took some items that I didn't pay for.
All right, tried to walk out of the store without paying for them?
Yes, sir.
Store was open to the public at the time?
Yes, sir.
You didn't have anybody's permission to take that property?
No, sir.
And this property you took was offered for sale?
Yes, sir.
And this is a second based upon value or prior?
That's based on value, Your Honor. It was initially a first, based on it being a subsequent, but.
Got it. Ma'am, was the items that you took, was the aggregate value of that in excess of $200?
I don't know exactly how much it was.
If I said it was $337.98, would you have a reason to dispute that?
No, sir.
All right. And so you'd stipulate or counsel agreed that that's the case?
Yes, Your Honor.
Yes, Your Honor.
All right. Ma'am, if I do accept your plea, if between the time of plea and the time of sentencing, if you commit misconduct as defined by the Michigan court rule, you would not be entitled to any sentence, the court would not be bound by any sentence recommendation to it, and you would not be permitted to withdraw your plea. You understand that?
Yes, sir.
Is that a yes?
Yes. Yes, sir.
Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
No, Your Honor.
I'm not, Your Honor.
And have I complied with the court rule? Would it be proper to accept this defendant's plea?
Yes, Your Honor. Yes, Your Honor.
Yes, Your Honor.
Court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 14A1. Probation sentencing will be
October 8th at 9 a.m.
October 8th, 2025, 9 a.m. That's before me. Bond will continue.
Thank you, Your Honor. Have a nice day.
Thank you. You do the same.
Thank you, Your Honor.
Everyone can remain seated. Court will stand in brief recess.
Done. Congratulations. Well done.
Thank you so much,
Mr. Laux,
Judge.
he's going to give you a copy of the entry that I just signed and filed
All right.
for your records, okay?
Thank you so much.
Judge Brian Bowling, Assistant Public Defender on behalf of Ms. Barfield. State your name for the record, please.
Kimani Barfield.
Thank you. Your Honor, there is a green form in the file. I'm asking for an adjournment. Ms. Tanha and I have discussed some possible discovery that might be outstanding, so we're hoping to get to the bottom of that. So we just need a date to come back.
Thank you. October 9th, 2025, 9 a.m. Bond continued.
Thank you, Your Honor.
Okay. Court calls case People versus Michael. Is it Gotchentower?
Brian Bowling on behalf of Mr. Guttenauer?
Gokenauer.
Your Honor, I'm also seeking an adjournment in this matter so that Ms. Feltus and I can have some additional plea discussions related to this case. So there should be a green form in the file on this one as well. And then I'd like to address bond if I could when the court's prepared.
I'll adjourn this one to September 30th, 2025 at 9. Yes, that's the bond.
Thank you, Your Honor. The current bond in this case, to my understanding, is a $5,000 10% bond. Mr. Gokenauer lives in the city of Detroit, Your Honor, by himself. However, he does have a 9-month-old daughter with his significant other that he is active in that child's life. He works as a plumber. He has jobs scheduled and in progress here in Michigan that he would like to get back to. We'd ask the court to consider granting my personal bond in this case.
Respond.
Your Honor, I do have to, my office requested a monetary component at the time of arraignment. I will note that the defendant does have a pretty significant multi-state history. So I wonder if that was a basis for setting the bond, if the magistrate did. And it does look like he completed a prison term for a larceny, 1,000, 20,000 in April, and maybe completed a parole in April of 2025, but it could have been a prison term.
It was because of the relationship to this offense to parole that caused the monetary bond.
That makes sense, Your Honor. Thank you.
Anything additional?
No further.
Motion for bond reduction is denied. Bond will continue.
Thank you, Your Honor. Your Honor, I missed the date. I apologize.
The date is September 30th.
Thank you, Judge. Mike. Thank you, Your
Honor. Can you hold Ann needs to go on. Court calls the case People versus Anita Barnes.
Anita Barnes.
Brown appearing on behalf of Mr. Barnes, Your Honor.
What are we doing?
I'm requesting adjournment.
May I say something, please?
Well, we're in court.
Can you what?
She wanted to
May I
talk to
say
me,
something,
but
please? No, I mean to the judge, to everyone. May I say something?
Go for it.
I would just like to say that I feel quite a bit of confliction here. I am still not very clear on why I'm even in court, and my attorney keeps getting changed, and it keeps getting adjourned, and no one's in clear communication.
Ma'am, I'm going to stop you. If you're worried about the attorneys getting changed and communications there, we can solve that problem by having you come down. I'll hold your file today, and then you'll be able to get a clear understanding from me directly as to what you're charged with. I don't mind going through an arraignment again, and then you can talk in detail with Mr. Brown if that's what you'd like to do.
I just would like for someone to be able to reach a little bit more out to me. I'm struggling with my transportation right now. I don't have the means for Uber, and my living situation isn't the best. I'm in a hotel, and I'm just trying to make sure I'm as clear as possible with everything that's going on as well.
Okay, I understand your concern, and I'm sure that the Public Defender's Office does everything they can to communicate with you. It sometimes can be difficult when the client doesn't appear here and is requesting to appear via Zoom, because even the conversation on this day can't happen. So if what you'd like me to do, given the adjournment, is set it the next hearing, if you don't believe that there's communication, I'll make sure the two of you get together because I'll demand that it be in person and you'll have to be here. If that's what you'd like me to do, I'll be more than happy to do that.
I don't mind trying to set it up beforehand, but honestly, I just started a new job and things like that. As long as it's far enough for me to actually be able to make it, I would like to show my best appearance and be a part of these things. I don't mind. I just haven't had the chance to.
What do you want me to do?
And, Judge, anything that you find worthy. I appreciate being able to show up Zoom. But if the problem is me being here by Zoom, I will try my hardest to make it there. I just don't want to get in trouble because I couldn't make it there.
Mr. Brown, where are you at?
Pardon me?
What do you want me to do? I don't understand what you want me to do, ma'am.
I'm requesting adjournment on her behalf, but I'll be here till 4 o'clock. She wants to come on down. I'll be happy to talk.
You hear that, ma'am?
Yes, I do.
Mr. Brown is very dedicated. He'll be here till 4 o'clock. All right. So if you want, if you're worried about communication and something, he will make himself available.
Okay, thank you.
Right. So you coming?
I will try my hardest. If I'll call the prosecutor's office to get your information so that I can contact you.
How about we just adjourn it and we set a meeting where you come to my office?
That would be the best.
No, she should come down here by 4. You'll be here.
Oh, okay.
I can't guarantee that I can be there by 4. I have to get my daughter from the bus stop at 4:17 exactly. And I have to figure out if anyone can give me a ride out that way first. I don't have a vehicle.
All right, I'm gonna let you guys work it out.
I'm just requesting adjournment, John. That's all.
Probable cause conference will be adjourned. I'll give you guys time to try to work this out. October 9th, 2025, 9 a.m.
You want my number again?
Yes, please. I do not have it.
222-6970.
Okay.
Okay, I'm on it.
Thank you.
All right, bond will continue.
Okay.
Let's call the case. People versus Christopher Griggs.
Morning, Your Honor. Raymond Cook for the people.
We're ready in this now.
Ron Brown, Deputy Chief Public Defender, appearing with and on behalf of Mr. Griggs. Mr. Griggs, please state your name for the record.
Christopher Griggs. Thank you.
Your Honor, today is the date and time set for the probable cause conference. We are respectfully requesting that this matter be set for preliminary examination.
All discovery is complete.
To the best of our knowledge.
People have their witnesses available the 30th.
We'll do our best, Your Honor.
Preliminary examination in person will be set September 30th, 2025 at
9 a.m.
9 a.m. before Judge Washington.
Very briefly address the issue of bond.
Very briefly.
Thank you. Your Honor, my client has a home in the area in which he could stay. The facts of this case is he's charged with CCW. He was driving a vehicle. That vehicle was pulled over for issues. Was not his vehicle. The owner of the vehicle was sitting in the car next to him. There were weapons found that were not in plain view. And he was subsequently charged merely for being present at the same place the weapons were eventually found. We're asking that, as we do not feel that the likelihood of conviction is very strong in this case, that his bond reflect that. He will return to all future court dates. He will abide by any strictures that the court place upon him. He's asking that he be allowed a personal recognizance bond in this case.
Your Honor, I do know the defendant does have some criminal history as the court can see from the charging documents. One of them was it was possession of a short barreled rifle or shotgun. The convictions are relatively old. The most recent one I see is from 2018 for an OWI. Or as defense counsel indicates, the weapon that was found in the vehicle, which the vehicle is not his, but the weapon was found in the center console and he's driving it. The other passenger also indicates it was not hers. And so there is some concern whether the strength of that case and the likelihood of conviction, that's obviously up for a potential jury to determine at that time. But I just have some concerns given the prior history. I'll leave it at that.
So, Your Honor, to respond to what he said, the person, the passenger was the owner of the vehicle. When they stopped it, my client was very calm, very cooperative. It was the passenger who owned the vehicle who was behaving in a nervous and strange manner. Again, there's nothing that connects. Well, we don't want to get too far in the weeds on this, but essentially, I do not believe that the prosecution is going to be very successful in going forward on this case. So I'm asking that a bond reflect that.
Bond is actually, quite frankly, for a weapons charge, very low at 5,000 cash or surety. So it's at a $5,000 bond. I don't think that is an abuse of discretion. I'm not going to change it. As bond, most for bond reduction is denied. Bond will continue. Certainly we can bring it up, but whatever. Court does call the case of the People versus Crystal Barnes.
Assistant Public Defender Chelsea Rigios with and on behalf of Crystal Barnes, who appears via Zoom. Ms. Barnes, please state your name.
Crystal Denise Barnes.
Your Honor, we're asking to adjourn. I've spoken to prosecution about how I'm requesting some additional discovery.
Any objections?
No objection.
Did Mr. Brown sort of grant you with his grace of not having to get me a green sheet because of age?
I thought I turned in the green sheet. I'm sorry.
No.
I will fill one out immediately. I apologize.
That's okay. Ms. McGill, you are always very good at that. I am blaming this solely on Mr. Brown.
That's right.
Because I know that it's his fault. Probable cause conference will be adjourned to October 9th, 2025, 9 a.m. Bond continued.
Thank you.
Thank you.
Thank you.
The baby.
Court calls the case People versus, is it Jakeeb's Gully?
We're ready now. The Chief Public Defender Attorney Ribbon on behalf of Mr. Gully.
Your name, sir? Stevie is good. First name is, say it again.
Don't worry about it. You ain't gonna get it.
You said I'm not gonna get it? I'm gonna call him Joe then. Go ahead. What are we doing?
Your Honor, in this matter, we are respectfully requesting this matter be set for a preliminary examination.
All right. Discovery is complete to your knowledge.
To the best of our
knowledge. Well, there witnesses available the 30th.
We'll do our best.
Preliminary examination in person, September 30th, 2025 at noon. That's before me. Oh no, I gotta try to say his name again, but he won't even give it to me. That's all right. All right. Bond will continue. All right. Thank you. Thank you, sir. Court does call the case of the People versus Michael Boyce Smith.
Brian Boyce Smith, Judge. State your name for the record.
Michael Boyce Smith.
Your Honor, I'm asking this matter be set for a preliminary examination. I believe all discovery to be complete.
People have their witnesses available the 30th. Preliminary examination in person will be set September 30th, 2025, 9 a.m. That's before Judge Washington.
Thank you, Your Honor.
Bond continued. Thank you. For calls case of the People versus Andrew Harrison.
And Assistant Public Defender Jay Bellinger on behalf of Mr. Harrison, who approaches. Can you please state your name for the record?
Andrew Marquise Harrison. Thank you.
And Your Honor, we are just asking to set for a preliminary examination today. My understanding is that all the discovery is complete.
And Your Honor, for the record, we made an offer to defendant through the counsel. This defendant has 2 misdemeanors in 15th District Court as well. So the offer would be to plead to GBH strangulation, which is count 1 in this case, as well as the domestic violence and the stalking he has against the same victim in the 15th District Court. That offer has been rejected and we're ready to move to.
That is our understanding of the offer, Your Honor. He's going to give you a date right now, and my client is rejecting that at this time.
Preliminary examination in person will be set. People would have their witnesses available the 30th.
I'm sorry.
The 30th.
I believe so, Your Honor.
All right. September 30th, 2025.
Okay. Yep.
At noon, that's before me.
Thank you, Your Honor.
The bond will continue. Court does call the case People versus Leticia Brock.
Good morning, Your Honor. Raymond Cook for the people.
Under Hannah Apple, on behalf of Ms. Brock, who's attorney to Zoom. Ms. Brock, will you state your name for the record? Yep, she's there.
Ms. Brock, can you, oh, there she is. Can you state your name, please? Okay, I've seen her.
There she is.
Okay.
Thank you. Your Honor,
Ma'am, we're just gonna shut your video real quick so that
can you hear
in case we
me?
have to ask you something, we'll hear you. Go ahead.
Your Honor, we're asking for an adjournment. We did receive the discovery, but however, we're asking for some additional time to review the video with my client.
All right. Without objection, probable cause conference, October 9th, 2025, 9 a.m. Bond continue.
Thank you.
That's called the case People versus Marcus Jackson.
Good morning again, Your Honor. Assistant Public Defender Davi Leva on behalf of Mr. Jackson, who approaches from my right.
Jennifer Douglas for the people.
Your name?
Marcus Jackson.
Thank you.
And Your Honor, we are requesting adjournment today. I've provided a green sheet to the clerk, and I would be asking to address bond.
Probable cause conference will be adjourned September 30th, 2025, 9 a.m. as the bond.
Thank you, Your Honor. Mr. Jackson is currently being held in a $500,000 cash or surety bond. We would ask the court to consider a lower bond or perhaps even a personal bond with a home confinement tether. He does have a full-time job at Promortis Renewable Energy, and he's very concerned that job will be lost if he remains in custody. He does have a place to stay in Dundee at an address that I can provide to the court. And again, we have no objection to home confinement tether with release for work. I do also want to note that he has ties to the community, including the support of his fiance, who is present here today.
Response.
Your Honor, the people would object to a reduction in the bond. We believe that Mr. Jackson poses a danger and a flight risk. The reason that Mr. Jackson's bond is so high is based on some of these allegations. It's that police tried to effect a traffic stop after seeing him run a red light. And that not only did he not stop, but that he fled at some point, drove in a circle around the police car, and continued to drive at a high rate of speed, doing U-turns, going into a parking lot, running multiple red lights, that he was driving in and out of oncoming traffic lanes, trying to evade the police, that he ended up intentionally driving headfirst into the vehicle of a police officer, disabling it with the crash, and continuing to drive, and while trying to get away, ended up hitting two other police cars. When the car finally stopped, when police had pinned him in, he's accused of fleeing on foot. He did have a passenger in the car. The passenger stayed there, said that did not know why Mr. Jackson had fled, and he was just a passenger. He spoke to police and cooperated with them. However, Mr. Jackson fled on foot. Police tried tasing him multiple times, and eventually had to just tackle him. He continued to try to get away from police once they had physical hold of him, Your Honor, and the police indicated that he smelled of alcohol. Now, Your Honor, he was recently arrested for OWI on August 17, 2025. Our office does have that warrant request, however, it's not yet been charged. And so, Your Honor, we do believe that there's a danger here and that him being arrested on August 17th for OWI, and then him being arrested this time with the driving that we saw and smelling of alcohol, and allegations of drinking and driving in this case. I'd also note that he does appear to come from Georgia. His license is from Georgia, and so we do think that there is some flight risk here based on that, and that is why we believe that the bond is appropriate as such.
I just want to make sure I heard that correctly. He went headlong. into a police vehicle?
Yes, Your Honor, a front crash, disabling the vehicle, and that car is unable to operate.
You got anything else to say?
No, Your Honor.
Before I deny your request?
No, Your Honor, but
All
I
right,
appreciate the
motion for bond
consideration.
reduction is denied. Thank you. Bond will continue.
Should be appearing in the Bureau of Prisons. They can't document 507, the one that's unmuted.
Got it. Court does call the case of People versus a Johnny Wright.
Anjanae Wright.
Anjanae, I'm sorry. It's been a morning. We thought that was you that had dialed in. All right.
Good morning, Your Honor. Tina Saxon on behalf of Anjanae Wright.
All right. What are we doing on this?
Your Honor, I was just appointed yesterday and I have not even had a chance to speak to Ms. Wright. I'm asking for an adjournment.
You're in the Bureau of Prisons, correct, Ms. Wright?
Yes, I am.
In Minnesota, Your Honor, so I'm also trying to get on the list so that we can have a conversation or video visit.
What I'll do is I'll adjourn the probable cause to October 23rd, 2025, 9 a.m. Bond continue.
Thank you, Your Honor. Have a great day.
Thank you. Thank you, Ms. Wright.
Thank you.
Court does call the case.
Sorry.
Court does call the case People versus Marvis Jones.
Assistant Public Defender Jay Bellinger on behalf of Mr. Jones, Your Honor. Mr. Jones, can you please state your name for the record?
Marvis Keaton Jones.
And Your Honor, we are just asking to set these for preliminary examination today. It doesn't look like we're getting an offer on these.
Pardon? Doesn't look like.
It doesn't look like there's an offer at this time on these cases, Your Honor.
And discovery is complete here.
To the best of our knowledge, Your Honor.
People have their witnesses available the 30th.
Do our best, Your Honor.
Preliminary examination in these matters will be set for September 30th, 2025. 9 a.m. before Judge Washington.
And Your Honor, if I may briefly address bond.
May.
Your Honor, my client is currently on parole. He advises that he can live in parole housing in Toledo, where he would be supervised by parole. During my understanding is that these cases are 5 to 6 years old. They're not violent offenses that are being alleged here. In 2020, when he didn't, I understand that the warrants have been out on these for quite some time, obviously. In 2020, at the time that the warrants were issued, my client lost his daughter, unfortunately, due to gun violence. That took precedent in his life at the time over these. My client understands the serious nature of these cases and is willing to obviously appear for them. I understand he's in custody right now, but he does assure the court that he would be willing to appear. Like I said, he has supervision in Toledo where he can stay in parole housing. So we would just be asking for his release at this time.
Response.
Your Honor, defendant was on benchmark status for multiple years and never turned himself in. I have concern risk, especially if it sounds like he's going to be residing out of state. I have further concerns that he's not going to return back. He's going to just let these go into benchmark status again. I'd ask the motion to be denied.
And Your Honor, if I may briefly respond to that, my client was in prison at the time that this happened as well. So there was not much of an option for him to address these. He did attempt to do that so that he could see about getting time served on these at the time, but he was unable to do so.
This time there are 3 cases. Preliminary examination before Judge Washington. So on the 30th, given everything, court is going to decline to reduce his bond at this time. Motion for bond reduction is denied. Bond will continue.
Thank you, Your Honor.
Yeah, you did.
Close case of the people versus Maurice Burgess.
People.
Assistant Public Defender Jay Bellinger, on behalf of, but not with Mr. Burgeons, Your Honor. We have just spoken to Mr. Burgeons' wife about 20 minutes ago. My understanding is that he's on his way to court. I understand that there's also.
Where is he?
Your Honor, I did.
Got some real problems.
Your Honor,
and I want him here now.
Your Honor, I do understand that as well. If the court would be willing to pass this case to the.
Absolutely.
Thank you.
I want him here in the next 5 minutes.
I will do my best, Your Honor.
I'm taking him or you. See how good he does. What, everybody's trying to hold him up now, so take him. Melissa Konwinski.
Assistant Public Defender Chelsea Vergils with and on behalf of Melissa Konwinski. Ms. Konwinski, please state your name.
My name is Melissa Marie Konwinski.
Can you sign here to waive the preliminary exam?
What are we doing?
Your Honor, my client is currently signing a preliminary exam waiver form, so we would ask to waive that and get up to circuit court. I would also ask to address bond.
Ma'am, you're waiving your right to a preliminary examination?
Yes, Your Honor.
You understand that a preliminary examination is a proceeding where the people would have to show by probable cause that the offense alleged was committed and that you committed it?
Yes, Your Honor.
You understand you'll not have that hearing, you'll proceed to circuit court for further
Yes, Your Honor.
resolution. People also waive their right.
You.
Preliminary examination having been waived, defendants bound over to circuit court on a single count.
We acknowledge receipt of the information, waive its formal reading, and stand mute.
Defendant able to be formal reading, standing mute, court will enter not guilty plea. Pretrial will be set for
September 30th at 1:30.
September 30th, 2025, 1:30 before Judge Simpson. As to bond.
Your Honor, we are asking for release on a personal bond with a scram tether, or if the court is not willing to consider that today, we're asking to set a cash bond because I believe her bond is currently denied. And I believe her current actions while in custody and her plan for being out of custody demonstrate her commitment to her sobriety. So in custody now, she is going to church, she's going to AA, she's enrolled in Dawn Farm. She has been also taking mental health classes. Her plan for when she gets out of custody is continue with the AA, of course, with her fellow Bear River alumni and to do intensive outpatient with Trinity Health. We do actually have printed out her email confirmation that she has an appointment on September 22nd. Very much like to be at that appointment and get going with her intensive outpatient treatment. Again, coupled with the AA classes, her continued mental health treatment with CMH, I think that she has compiled a great plan to hopefully have success with her sobriety.
Response.
I think the court recalls.
I do.
Thank you, Ms. Konwinski, and the concern of the people, it's multiple, but on an OWI with BAC of a 0.28 with a crash that she fled the scene from and 2 priors from 2021. And then drinking while on bond, I have significant concerns, which are not alleviated by the then lying about it being mouthwash and about, sort of making excuses for herself. Glad to hear things have changed. Glad to hear things are getting better in jail. But if the court is going to consider any release, I would request that it be with a scram tether.
At this point, given everything, I understand the plan. I understand where she's headed. However, she was basically almost a 0.3. She gets a PR bond with a release to tell her not to drink, and she just can't do it. Even though that's there, I think there's going to have to be a little bit more structure from my standpoint before I would release her. So at this point, your motion for bond reduction is denied, and her bond will continue as denied.
Okay.
Court does call the case of People versus Nicholas Chalmers.
Assistant Public Defender Chelsea Vergils on behalf of Nicholas Chalmers, who appears via Zoom. Please state your name.
Nicholas Chalmers.
Thank you, sir.
We are asking to adjourn for additional discovery. Does the court happen to have a green sheet?
I do.
Awesome.
Without objection, probable cause conference will be adjourned October 9th, 2025, 9 a.m. Bond continued.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you, sir. Court does call the case of the people versus Dion Richmond.
Andrew Baptist. Ready, Your Honor. Assistant Public Defender Jay Bellinger on behalf of Mr. Richmond. Mr. Richmond, can you please state your name for the record?
Dion Richmond. Thank you.
And Your Honor, we are asking to set this matter for preliminary examination at this time.
Discovery complete.
To the best of my knowledge, Your Honor, I also understand that there is a tentative offer. I have not been able to go over that with Mr. Richmond. However, I'm still working out the details of that. If we are able to resolve prior to preliminary examination, we certainly will.
People have their witnesses available the 30th.
I believe so, Your Honor.
Preliminary examination in person, September 30th. 2025, 9 a.m. That's at noon. At noon, that is before me.
Thank you, Your Honor.
On continued. Court does call the case People versus LaShawn Charles.
Assistant Public Defender Jay Bellinger on behalf of Ms. Charles, who appears via Zoom. Ms. Charles, can you please state your name for the record?
LaShawn Charles.
Say your name again, please.
LaShawn Charles.
Thank you.
And Your
You're
Honor, I am just asking for an adjournment on this matter. I am still trying to work out some sort of resolution for Ms. Charles at this time, so I'm just asking for 2 to 3 weeks.
Probable cause conference will be adjourned October 9th, 2025, 9 a.m. Bond continues.
Thank you.
Thank you.
Thank you, Your Honor.
Thank you, ma'am. Court does call the case of the people versus Javier Ruda. Javier Ruda, I jumped to this.
Bring it to the people.
Ron Brown appearing on behalf of Mr. Ruder. Sir, can you introduce yourself?
Javier Rueda Noguera.
We'd ask the court to set this down for preliminary examination. See if the witness can show up.
Discovery is complete.
To my knowledge, Your Honor.
People have their witnesses available the 30th.
We'll do our best.
Preliminary examination will be set September 30th, 2025, 9 a.m. before Judge Washington. Bond continued.
I'll come talk.
Court calls case People versus Tristan Clay Radcliffe.
Morning, Your Honor. Bring it to the people.
And Assistant Public Defender Jay Bellinger on behalf of Mr. Clay Radcliffe. You state your name for the record. Tristan Clay Radcliffe. And Your Honor, I am asking for an adjournment on this matter. We just need to confirm that restitution was paid in full before discussing an offer on this. My client advises that he paid restitution in full in January, so we did give that information over the prosecution. So just a couple weeks so we can see.
But not to the court. So it's not something the court could track. He paid it.
Correct. He paid that way back in January, Your Honor.
To the court?
Not to the court, Your Honor.
Not to the court.
Correct.
And that's accurate, Your Honor. I just received that documentation from opposing counsel this morning, so I just need to confirm with the victim to make sure that that was paid.
Probable cause conference will be adjourned September 30th, 2025, 9 a.m. Bond continued.
Your Honor, I did supply the court with a stipulated order for amended bond for my client.
I know.
Oh, okay. I'm sorry. Is that something that the court is willing to sign? Maybe you said something and I didn't hear you. I
Is
apologize.
your other client here yet?
I'm working on it, Your Honor. Diligently.
So he wants me to do something here, and I asked him to do a little thing again, and he won't do that. So I probably shouldn't sign his order.
Oh, well, that has nothing to do with this guy.
This guy being your client?
Correct.
Hey, you're right. I've already signed.
Thank you very much, Your Honor. Thank you. Thank you, Your Honor.
Did you see what he, has nothing to do with this guy. Court calls the case, People versus Jeremiah Sawyer.
And for those people,
Judge. Court will please to Assistant Public Defender on behalf of Mr. Sawyer, who is approaching the podium. Mr. Sawyer, when you get here, please state your name for the record.
Jeremiah Sawyer. Thank you, sir.
Thank you, Judge. I have reached out to the people and I spoke with Mr. Sawyer. We are asking for a brief adjournment to continue negotiations.
Probable cause conference will be set September 30th, 2025.
Thank you very much, Judge.
And bond continue.
We'll be in touch.
Thank you.
September 30th.
Court does call the case People versus Allen Cleaver.
People.
Good morning again, Your Honor. Assistant Public Defender Deputy Lebo for Mr. Jake Welling Cleaver.
Your name? Jake Cleaver. Correct. Got it.
And Your Honor, we are requesting an adjournment of about 3 weeks, and I have provided a green sheet. Welling.
It'll take you 3 weeks to review discovery.
We also would like to begin some negotiations, Your Honor.
Probable cause conference, October 9th, 2025, 9 a.m. Bond continue.
Thank you, Your Honor.
Court calls case People versus D'Angelo Simmons. I gotta squeeze in.
Ready to go, Judge. Court shall please to Assistant Public Defender on behalf of Mr. Simmons. Mr. Simmons, please state your name for the record.
D'Angelo Simmons.
Thank you, Judge. My understanding at the last court date, the competency was, he was found competent. We are still negotiating with the people to try to find a potential resolution on this matter. We'd ask for an adjournment.
Is this the only thing he's held on, or?
As far as I know, Your Honor.
Probable cause conference will be adjourned September 30th, 2025, 9 a.m. Bond continue.
Thank you, Judge. We'll be in touch.
Court does call the case People versus Deshaun Clifton.
This is Public Defender Hannah Apple appearing on behalf of Mr. Clifton, who's approaching now. Your Honor, Mr. Clifton has executed a preliminary exam waiver.
Say your name.
Yes.
Deshaun Clifton. Thank you. You signed this examination waiver? Yes, sir. You understand that a preliminary examination is a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them. Yes, sir. You understand you'll not have that hearing, you'll proceed to circuit court for further resolution. Yes, sir. People also waive their right.
yes, Your Honor.
Preliminary examination having been waived, defendants bound over to circuit court on counts 1 and 2 with 3 following.
Your Honor, we acknowledge receipt of the information. We'll stand mute, wait for more reading.
Defendant having waived formal reading, standing mute as to all 3 counts, court will enter a not guilty plea. Pretrial will be set for
November 10th at 1:30.
November 10th, 2025, 1:30 before Judge Hammoud. Thank you, Your Honor.
Your Honor, if I may also place on the record, that waiver was made. There is an offer that he would plead to count 1, count 2, and 3 would be dismissed. There was discussion of adding a count 4 for reckless driving that will not be added based on the waiver.
And that's correct, Your Honor.
All right, very good. Bond will continue.
Thank you.
Thank you. Court calls the case of the People versus Bosley Smith.
Good morning, Your Honor. Marie Campbell, Assistant Prosecuting Attorney on behalf of the people.
And good morning, Your Honor. Sydney Rushing, P 78820, appearing on behalf of Mr. Smith, who's approaching the podium. Mr. Smith, can you state your name for the record?
Bosley Smith. Thank you.
Your Honor, we have not received discovery yet in this matter. I did request it. I received a response asking for the signed order of my appointment. I did say that I had the one that was submitted to the court along with Ms. Wheatling's response saying that it was signed, and then they left me on red, Judge. So they didn't want to send me the discovery prior to.
Wow. That was really accusatory. Is that what they did?
I received a response. So that's what I think happened. They left me on red.
Okay, so just knowing how this is gonna work, I'm sure we have a response from Miss Tana. Go.
Thanks, Your Honor. Ms. Rushing, if you want to send it directly to me, I'll make sure it's taken care of on that not aware of what happened or who left you on red. It certainly wasn't me personally. I would never do such a thing. And Ms. Rushing, there is something important I do need to discuss with you, part of this case that I forgot to put on the record. So, if you could email me or get in touch with me somehow as soon as possible, I'd appreciate it. Your Honor, there's also an additional matter, this defendant making calls to the victim's number, the number that is listed in the police report from other and since he was arraigned. At the time that we looked into this, there were 7 calls made. The concerning part of this, in addition to the calls being made against his bond conditions and the privilege of being in the situation he is, the calls are concerning because he is having people instruct her essentially as to what she needs to do and not do, and so on. I haven't listened to them personally. I will do so. I'll make sure that Ms. Rushing gets those calls so that we can discuss it further. However, at this point, based on what we do have, I'd ask for his phone privileges to be removed.
Your Honor, if I may.
Yes.
I would ask that you consider putting this over for 1 week and before you're granting that request. I think I heard that people say that they haven't heard them personally yet either. So that means neither her or I have heard them to confirm what was said or what wasn't said. So I'd ask if you would consider just holding that order or motion in abeyance for 1 week for me to review them. That is my only request. Thank you, Judge.
And potentially have your client make additional calls to the victim, now knowing that they're on to it. I'm not going to do that. Defendant's phone privileges are hereby ordered revoked pending a hearing. And if you want a hearing on that, I'll be more than happy to set that up for you. Probable cause conference in this case, if you wanted to adjourn a week, I'll give you a week. I'll set it for September 25th, 2025, 9 a.m.
Thank you so much, Your Honor. I greatly appreciate it.
Thank you, Bond.
Have a great day to you and your wonderful staff.
You do the same. And I called your case, didn't leave you on red, right?
You didn't, Judge. I really appreciate that. You always make sure I'm taken care of. I appreciate it.
Thank you.
Have a great day, Judge.
Too. Court does call the case of the people versus Danina Combs.
Gosh, to call this for the people.
Ron Brown appearing on behalf of Ms. Combs, Your Honor. I was going to request an adjournment.
I'm sure you were.
I got your green.
In light of the violation?
Got your green paper.
Like Bellinger. I know. You.
Should I file it?
I'm here.
You can file it. I'm not. Is she here?
Yes.
What's your name?
Danina Combs.
She's got a violation, so she's going to need to appear personally.
You hear the judge? You got to come down. He wants to see you.
Your Honor, I got into a bad car accident and my back spine is broken in 2 spots. I can't.
Are you in the hospital?
I just got out.
Okay, so here's what I'm going to do.
Before yesterday.
I'm going to set this for 3 o'clock, giving you an opportunity, or for 2 o'clock, giving you an opportunity to send to Mr. Brown, who's apparently going to be here till 4. To send to Mr. Brown detailed information regarding that. Otherwise, I will expect you here.
Okay. I have the paperwork.
Okay, get that to Mr. Brown so he can let me know.
Okay.
Thank you.
Thank you.
Court does call the case People versus Matthew Verbeil. Mr. Bellinger, do you have your client yet, or do I need to send my people?
Your Honor, he is on a bus.
Okay, we'll talk.
And Your Honor, good afternoon, sister. Good morning, Sin Bloodfender Davi Liba with and on behalf of Mr. Verbeil. Mr. Verbeil, please state your name.
Matthew Verbeil. Thank you.
And Your Honor, we are requesting an adjournment today, and I have provided a green sheet to the prosecutor. I'm sorry, to the clerk.
The is that you guys doing investigation that's going to take a minute, or what?
Your Honor, so this is a matter involving a child abuse allegation. We've requested the CPS report. So it's going to depend on how quickly they will provide that to us.
Public cause conference will be adjourned September 30th, 2025. 9 a.m. bond continued.
Thank you, Your Honor.
Yes.
I have some additional.
Oh, okay, go ahead.
There is going to be a child advocacy center interview in this case, hasn't been scheduled yet.
Got it.
You may have an additional week just to ensure that.
That's fine. You have any objection to that?
I have no objection to that, Your
Okay,
Honor.
I was setting it that way so that because he was in custody, but my next date would be October 9th, 2025, 9 a.m. Bond continued.
Thank you.
Thank you. Court calls case People versus Rachel Corser.
Andrew Banish for the people.
Assistant Public Defender Chelsea Ridgefield with and on behalf of Rachel Corser, who appears via Zoom. Ms. Corser, please unmute and state your name.
Rachel Ann Corser.
Thank you.
Your Honor, we're asking to adjourn. There's very recently been an offer that I'm asking for time to discuss with Ms. Corser.
Probable cause conference will be adjourned October 9th, 2025, 9 a.m. Bond will continue.
Thank you, Your Honor.
Thank
You don't want to address bond? No, I'm kidding. Go. I'm sorry. Just. Court calls the case People versus Sean Beater.
Andrew Banish for the people.
Hello, your name?
Sean Vitter.
All right, what are we doing? Who's?
Case.
Who's? She was here. Yeah, one case. One case. She was here. When I call it, she's not.
Truth to that. Stephanie Cannon on behalf of Mr. Beater, who is standing to my right. Mr. Beater, could you please state your name for the record?
Sean Vitter.
We made his finding.
We have not made it as of yet, Your Honor. I did provide the court with paperwork as it relates to a finding of competency.
It's has started. It's passed.
Yeah, you did. You passed with finding?
Yes.
And so I did provide the prosecutor and this honorable court with that information, Your Honor.
Yes, and I have reviewed that. Is there any additional information either from the people or defendant?
Your Honor, we will stipulate to those findings. It is my understanding that paperwork for criminal responsibility has already been submitted. It's my belief and understanding is that.
I don't know about that.
December 4th, Your Honor, signed both the order for competency evaluation. It's now been found competent. People also stipulated to that. I have no further information on that. I saw in my file that you also signed an order for evaluation relative to criminal responsibility. I'm not sure if they're proceeding with that or not, but
I don't know if they are, but I wouldn't deal with it here. That will be dealt with in circuit court, so I'm not even addressing that. Having no other evidence as it regards competency, court upon review of that report would find that the defendant is competent to stay in trial, which finds specifically that he can understand the nature and objects of the proceedings against him and can rationally assist against defense. Therefore, the defendant is deemed competent. I do have order. I have signed that. You would like this set for probably. No.
Yes, Your Honor. I need the opportunity to speak with my client. I did attempt to do so twice this week, but there were some things going on at the time. It appears that he's a little bit better now, so hopefully I'll be able to speak with him prior to the next hearing.
Would you like the 30th or October 9th?
Your Honor, the 30th is fine.
All right. Probable cause conference will be set October 30th, 2025, 9 a.m. Bond continued. Thank you.
Thanks.
Can you sign this for me?
I don't really want to give my information out there.
Okay, that's perfectly fine. You don't have to. Thank you.
Court does call the case People versus Dustin Duncan.
Andrew Banish.
How you doing?
Brian Bowling on behalf of Mr. Duncan, who it's my understanding he's present on Zoom, Judge.
Yes, he is.
Yes.
And
Can you state your name for the record, please, sir?
Dustin Wade Duncan.
he needs to be here.
Right, Judge. Mr. Duncan requested Zoom, which was approved, then revoked based on the community corrections report that was issued in this court issuing a
So
bench.
how soon can he be here?
So, Your Honor, he's at the University of Michigan Hospital for a medical procedure right now. It's up to the discretion of the court. I mean, I think he
I'll set
could
it
probably
at
be
3
there.
o'clock. He needs to get here.
Okay.
Otherwise, there's gonna be a warrant.
Mr. Duncan, the judge is ordering you to appear here by 3 o'clock this afternoon, okay?
Okay, thank you, Your Honor.
Thank you.
Thanks, Judge.
Court calls the case people versus Jeffrey Williams. Let me get. This Mr. Williams?
It is.
It is.
Ron Pring on behalf of Jeffrey Williams. We sent over a form for him to be referred to the 15th.
What?
We sent a form over for the 15th mental health court.
I don't have any. When did you send that this morning?
Monday or Tuesday.
I'll sign off on it. I don't have a problem doing that, but I don't have it right with me right now. We'd
Yes,
have to
Your Honor.
turn it out anyway.